Lordship, I'd like to mention item number 11, Lordship. I have instructions to withdraw this writ petition. The petitioner has died, Your Lordship. The petitioner has died in the meantime, and I have contacted with the legal heirs. Lordship, they are not inclined to pursue the matter. Lordship, the matter was
Number
11, Your Lordship.
matter pertains to
Non-payment of contractor's bills, Your Lordship. H. Muzumdar, Your Lordship.
H. Majumdar, the learned counsel appearing on behalf of the petitioner submits that the petitioner had expired on
Lordship, on 30/9/2024, 30 September 2024.
30/9/2024. He had further contacted the legal heirs. And the legal heirs have informed that they are not interested in substitution. Taking into account the above, the instant writ petition therefore stands closed.
Deeply obliged, Your Lordship.
Copy of the death certificate is kept on record and marked with the letter X.
Lordship, I have also obtained the consent from the other side, Your Lordship.
X.
Yeah, please, Your Lordship. If I'd like to mention item number 44, Your Lordship. Lordship, it's a contempt matter. Your Lordship directed us to file our affidavit, Your Lordship. The affidavit could not be filed today, Your Lordship. I need further 10 days time, Your Lordship.
We'll have it when the matter reaches. Let's see what is written out there.
Lordship, item 51, supplemental motion. I have filed an additional affidavit today, Your Lordship. That may kindly be called.
May please, Lordship. Item number 49 may kindly be adjourned for the day only.
Item number,
49.
why? It has come up for orders.
Yes.
Why do you want an adjournment?
No.
You are for the petitioner.
Yes.
Why?
Actually, memos of parties is to be submitted, but I will.
Huh?
Memos of parties is to be submitted, Lordship.
Why you have not submitted?
Yeah,
We should strike out the names then.
I have prepared but could not submitted, Lordship.
Go and submit. We'll see when the matter is taken up. You say that the memo of parties have been submitted. Who there?
It's ready. It's ready, Lordship. I can.
Submit it, file it,
Lordship.
and then tell me that it has been submitted when the matter is taken up at
But
4:30.
the record is in the court, that's why they.
So what? You have to file it before the registry. You are not going to file it here. Go and file it before the registry.
May I please, Your Lordship? Lordship, with regard to item number 15, my lord, I beg to withdraw on instruction, my lord.
What's your name?
A. Gayan.
Mr. A. Gayan, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. You are appearing?
No, my lord.
Taking into account the above, the writ petition therefore stands closed on withdrawal. Interim orders, if any, stands vacated.
Much obliged.
Please, my lords. Please, my lords. Lords, in item number 21, my lords, we have filed a counter affidavit on Friday, my lords.
What?
Counter affidavit, my lords. In item number 21, we have filed it on Friday. My lords, may kindly call for this. Grateful, my lords.
May I please, Your Honor? I beg to mention item number 6. I may be granted 2 weeks time to.
Item number?
Item number 6. I may be granted 2 weeks time to file affidavit in reply against affidavit in
We'll
opposition.
see when the matter reaches. Now,
Wait, please, Your Lordship. I'm paying for listing of motion matter on Wednesday, Your Lordship permits, my lord.
what motion?
ESI demand was there. ESI demand, my lord. I made an application to allow me to deposit the same installment.
When is it?
Much obliged, Your Lordship.
For motion item 1.
May it please, Your Lordship? This is contempt petition, though, sir. Page 10 is the order.
Mr. B. Gogoi. We'll see when the matter reaches. Yes,
Lordship, these are legs in foot number
Okay.
20.
you are there also for NHM.
Lordship.
We find out why it has not yet. Have you considered the representation or not? I give you 1 week's time. Okay, give a copy to him.
Yes, ma'am.
Mr. So and so. who represents the NHM, is being requested to obtain instructions as to whether the order dated 17/3/2025, passed in WPC number 1448/2025 have been complied with or not. First of list this matter again on
Write down.
3rd of November 2025. A copy of the contempt petition be furnished to him, to Mr. So-and-so, during the course of the day,
Yes, sir.
so that he is in a position to obtain the necessary instructions. To stop. The name of Mr. So-and-so is shown in the cause list. To stop. List accordingly. For motion.
Item two,
Write down, when it speaks now. 3:11.
Yes,
Right,
Mr. Nicholas, what are you?
My lord, it may be dismissed, my lord. I will file a civil suit, my lord, because it is similar matter you have passed an order, my lord, 2014 matter, my lord. So I pray, my lord, I will, my lord, file a civil suit there, at Nagaon, my lord.
Therefore, heard Mr. Nicholas Raman, the learned counsel appearing on behalf of the petitioner, and Mrs. Radhika, who appears on behalf of the Water Resource Department. The petitioner herein have sought for appropriate directions upon the respondents for payment of an amount of rupees 4,76,894, claiming that the said amounts have been due to the petitioner. Petitioners, na?
My lord,
Petitioner.
only one petition.
One.
Stop. The learned counsel appearing on behalf of the respondent submits that the amount which the petitioner claims is of the year, it is pertaining to works done by the petitioner, but purportedly by the petitioner from 2014 to 10/3/2015. The learned counsel for the respondent submits that in a proceedings of the present nature, such inquiry nature, it would be difficult to make necessary verifications. Per contra, Mr. So-and-so appearing on behalf of the petitioner, submitted that the respondents have duly admitted the said. However, he further submitted that taking into account that there are certain aspects which would require an adjudication on facts, the petitioner would be well advised to approach the appropriate civil courts seeking adjudication. So taking into account the above, the instant writ petition stands closed on withdrawal. However, liberty is given to the petitioner to approach the appropriate civil court if otherwise permissible under law.
Right.
If it is admitted, why don't you file summary suits? It's very easy. File it under section order 37.
My lord, the other day, my lord, similar matter, my lord, you lost.
File some summary suits.
three,
Please, Your Honor.
30 days.
This is a matter pertains to the amendment of the provision of the clause 17 of the Assam Public Distribution of the Articles Order 1982. The page 33 is the particular clause. Clause 17.
So we are challenging clause 17 of the Assam Public Distribution of Articles Order.
Yes,
1982.
yes.
Why?
That's because, Your Lordship, the petitioner was running a fair shop. And in the meantime, he was being convicted in a particular case. Then his fair shop license was being cancelled when the case was pending in this Honorable High Court. The appeal was being admitted and the stay was being, the sentence was being stayed. Now, he was allowed to go on bail. Now, he has every right to earn his living for his family.
They have been allowed to go on bail.
Yes, he was allowed to go on bail when the appeal is.
No, you have been convicted.
Yes, I have been convicted in the High Court. We have made an appeal, criminal appeal.
So you have been only allowed to go on bail.
Yes, Lord.
So
But in the meantime, my license.
your conviction has not been stayed, your
Convic-
sentence has been suspended. So how does it matter?
Now, Lordship, the matter is that he has the right to earn his living.
No, you are convicted. You
Yeah,
are convicted. Why can, why on earth should you be allowed? You get a stay on the conviction.
now we have tried that, Your Lordship, but
Obviously, no court
the
passes that order.
the writ appeal is also pending before the Divisional Bench of Chief Justice and the Chief
What
Justice of
writ appeal?
writ appeal in regards to the license that was being cancelled. In that regards, the writ appeal has been pending therein. And the Honorable Chief Justice is also of the view that we must challenge this particular.
Okay, taking into account that I placed it before the Chief Justice.
Yes, sir.
Lahok. The learned, this is the present writ petition has been filed assailing clause 17 of the Assam Public Distribution of Articles Order 1982. It has been submitted by the counsel appearing on behalf of the petitioner that upon the conviction of the petitioner by the court of the
Additional District Judge number 2, Nagaon.
where is that
Sir.
order?
She will find the
Against the conviction of the petitioner?
19.
Huh? Conviction of the petitioner by the learned court of the additional sessions judge number 2 Nagaon in sessions bracket T2 case number 138 of 2016 by the judgment and order dated 18/3/2025. The petitioner's license have been cancelled in terms with clause 17 of the Assam Public Distribution of Orders 1982. नाम तो भल के साइल हो दोस्तों. The council submitted that an appeal thereagainst have been filed, whereby the sentence have been suspended. दोस्तों, be that as it may, against the cancellation of the license and a writ appeal is pending, being registered and numbered as
248.
248 of
Oblique 25.
oblique 2025. The learned counsel submitted that the instant writ petition is intrinsically connected with writ appeal number 248 oblique 2025. The registry shall is directed to list the instant writ petition along with writ appeal number so and so that the learned division bench is in a position to take up the matter.
Much obliged.
Supplementary item 51.
Please, Your Lordship.
Oh, yes. What has happened? You are ready.
Lordship, I have prepared a estimate for construction of the drain and we are ready to pay. Okay.
Construction of the
Drain, Your Lordship, in the campus. Drainage.
drainage won't do.
No, Your Lordship, because
To make it proper.
in the
Proper
RTI,
construction.
RTI reply, Your Lordship will kindly see.
What here reply be?
In the additional affidavit,
लिखने देते हैं लिखना है कहते हैं हाँ नहीं लिखने देते
As of now, nothing has happened.
Lordship,
No, it's-
premature lordship.
One is premature. Secondly, it is absolutely within your domain to do what it is.
Yes, no locus lordship. Two things, Lord.
Lordship, I've filed an additional affidavit, Lordship, today.
What is your additional?
The additional affidavit has not come, Lordship. This is.
Now, what is there?
Uh, Lordship, two documents I have annexed. One is the RTI reply, page 85, Your Lordship. Earlier, they had supplied an incorrect information, so they, after the filing of this case, they have issued this RTI reply. The total amount, now they have said that 42.79 lakhs has already been spent at Kabuganj office for building the Kabuganj office. And Your Lordship, at serial number 2, may I read, Your Lordship, after page 85, this is the revised RTI reply, 25/9/2025. At serial number 2, after restructuring of the department, the headquarter of this division was fixed at Kabuganj, Tholai. In this regard, one abandoned Assam type building was selected for office accommodation. Repairing works amounting to 15.83 lakhs were undertaken to make the building usable. For approach road and water supply provision, an additional 25.96 lakhs were utilized. However, during monsoon, it was observed that due to the absence of proper drainage facilities within the campus, the drainage facility has been pointed out. The floor of the office building remained damp, and the bathroom portion at the rear side of the building remained unhygienic during rainy season. Owing to these reasons, the division office could not be shifted to Kabuganj. Only this is the ground given, Your Lordship. Now, in the next paragraph also, they have stated that a proposal to seek additional funds from the government for campus development has been planned so that the said building can be used in future as a full-fledged office.
So very good. You should withdraw then.
Lordship,
You should withdraw. They're proposing to develop it.
develop.
Then it has been stated by this instruction that the executive engineer says that we are not taking any action. We have asked for permission. Whether the permission will be granted or not, that is another question. Once the permission is granted, then the question will be there. It is not the executive engineer who has the power to do anything.
Yes, Your Lordship. Only I had come up because at page 61, already a decision was taken by the executive engineer.
Understood, but does the executive engineer has any power?
No, no, Your
No, then
Lordship.
he himself says that he has placed it before the chief engineer.
Chief engineer
Even the chief engineer cannot change.
cannot change.
It has to be done by the government. Has the government done? The chief engineer has not said okay.
Yes,
Okay. Now, the instant with petition heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. N. Upadhyay, the learned counsel who appears on behalf of the irrigation department. The petitioner herein have essayed, the petitioner association have essayed the actions on the part of the proposed act have sought for interference of this court in the proposed move mooted by the executive engineer Dholai Sonai division to shift the headquarters from Kabuganj to Palonghat. This court sought for instructions from Mr. N. Upadhyay, the learned counsel, standing counsel of the irrigation department as regards the said proposal. To the said proposal, to the said instruction, to the said, pursuant thereto, Mr. N. Upadhyay has placed before this court an instruction issued by the executive engineer Dholai Sonai division, which is kept on record and marked with the letter X. From a perusal of the said instruction, it is seen that as regards the decision regarding shifting of the divisional office from the present camp office at Sonai Road, Silchar 6 to a new location does not fall within the purview of the executive engineer Dholai Sonai division. It was also mentioned that necessary correspondence have been initiated with the chief engineer irrigation for obtaining permission from the competent authority in that regard. Mr. Anupadhyay submits that even the chief engineer of the irrigation department would not have the authority for change of the divisional office unless and until the competent authority in the government of Assam does the needful. He therefore submits that the present petition is premature. This court, having taken into account the materials on the record and also the instructions so provided by the executive engineer, Dholai Sonai Division Irrigation, which is kept on record and marked with the letter X, is of the opinion that the present petition is premature, and accordingly, the instant writ petition therefore closed as being premature. Mr. B. Gogoi, one matter, contempt matter, item number 1. That person, your junior, I've asked him to obtain that instruction as to whether the representation has been disposed of next week. Let's find out. I put his name. He's also a standing counsel, and then I put your name. Yeah, B. Gogoi naam to didibo. Item number 1 put, huh? B. Gogoi.
52.
Yes, your
Yes.
matter at last.
My lord, I have filed the additional affidavit
That has still not come.
my document number is, my lord, 102/2025.
Yeah, the additional affidavit has not come again. You have not called today also. Something must be wrong.
There must be some objection, probably.
Mistake.
But so far as our information, my lord, there is no mistake, my lord, and that is the bench, my lord.
Chalo. I will take it up. Ask the registry why he has not enclosed. He's the along with the said affidavit. Ordered yes. Does not find that. We take it up at 2. Well, get that. You give the requisition slip.
May I please, your lordship? Matter pertains to non-issuance of site visit certificate, my lord.
What certificate?
Site visit certificate, my lord.
Side visit certificate.
Geotech photographs has already been taken.
29/10 is the
Last date, my lord.
The instruction.
29th.
Okay.
Similar order is also, I have like enclosed, my lord. Page number 30, my lord.
Tomorrow.
29th is the last date.
You have visited.
Yes,
Where's the geotech certificate?
Geotech, they have given an page number 25, my lord. Annexure 3. 25, 26.
Which are the works?
My lord, it's a Gopur Kamdelwal Hawazan Road under Assam Mala 3.0. Up
810. And notice inviting tender is 810.
8.
Which are the works we are concerned?
Gopur.
Serial number
Go-
1.
one.
Vishwanath.
Viswanath.
Yes.
Last date of submission is
29.
2910.
No.
Tomorrow.
When did you apply?
On 14/10. Page 23.
How can you apply on 1410? This certificate?
1410 is the deed document.
What?
1410.
Page 23.
Page 23.
You have asked on 2310, not 1410.
1410. My lord, a letter, these two representations, they.
No. First of all, you need to visit. You visited only on 2110. In that, Annexure 3 and Annexure 4.
Yes. 28. Yes,
Hmm.
28.
Then you asked on 2310. Then
The geotech has, they have taken the geotech photographs also, my lord, then they have visited.
you have taken the geotech photograph on 2110, not on 1410. And in fact, madam, I should dismiss your writ petition in the manner in which you have enclosed this document.
Which one?
Where the date half is scrambled up. Do you see page 25? Tell me the date. Tell me the date.
No, my lord, I haven't seen.
Then you have to be careful when you are before the court.
Let's-
And why are there two different things? One is Kamdewal and the other is Notun Kotha. Why? So you are asking for issuance of citing, sir, in respect to road name Gopur Kamdewal.
Hawajan.
So you have visited which area?
They visited the Kamdelwal.
What? You are not aware.
Yes, I'm not.
Because one is different, one is different. One is Kamdewal and the other is Notun Kotha. Which one is relevant?
My lord, Kamdewal.
Then why
Because
you are enclosing the other one? Sorry, state of affairs. Okay, we have it tomorrow. Tomorrow is 28th, na?
Yes.
Can you have it by 2 o'clock? We finish it off. Unless you say this thing, because again it will get prolonged. Just get your instruction why this has not been issued. 2 o'clock.
Till list item 4, order no steps.
Item 4.
Yes, why no steps?
Your
Why
Honor.
no steps?
This matter this matter has appeared infractuous.
What is your name?
S Nandi,
Yes?
Nandi,
Yes, Nondi.
on behalf of BD Con.
Your name is not here.
I am appearing on behalf of BD Con.
You cannot appear. Yes, what do you say?
My lord, here, the sanction was given long time back, my lord, so.
Has it become infructuous?
Because they have applied for MFL onshore. Yes. So that proposal was sent to the government for commissioner. In the meantime, some public complaint was there. So they were asked to furnish a fresh NOC. But in the of that instruction logic, they have not furnished that. fresh NOC.
Parikshit.
For their NOC.
Parikshit. But a shock is the one.
Mr. S.R. Burwai, the learned counsel appearing on behalf of the District Commissioner Bongaigaon submits that the petitioner was asked to provide a fresh no objection certificate from the president of the concerned government chair. Until now, the said no objection certificate have not been produced as per his instructions.
The date of the instruction.
It further appears that the petitioner herein have also not taken steps. Under such circumstances, it is therefore the opinion of this court that the petitioner is not further interested in the proceedings, and accordingly the writ petition stands closed.
For admission item 5,
In that writ petition,
So, my lord, my name doesn't appear on the court's
Okay.
list.
for admission item 5,
you are there, item number 5.
Name is not reflected.
What is this?
Mem-
Affidavit filed.
Yes.
Yes, argue.
The private respondent is yet to file their affidavit.
Forget about that. You argue your matter. It has come for admission. We may dismiss it on this ground itself. We don't have a case. What What is his case?
No, my lord, we have the case.
This is the state of affairs, the counsel for the petitioner doesn't know his case. Yes, let me, take the help from the counsel from the respondent. Mr. Bottago, what is the case of the petitioner?
He's praying for shifting, permission for shifting of his IMFL shop. But my lord, in our affidavit, we have stated that even before the permission was granted, he has already started operating in the proposed shop, my lord, which had to be closed later because complaints were received. Who are arrayed in this writ petition, my lord, private respondent 6, they had filed a complaint and therefore they were required to submit fresh NOC, and they were already operating on the.
Have you closed down?
Yes. It
Now
is
he's not
yes,
operating anywhere.
operating. Yes.
Fantastic. Affidavit you have filed,
Fine.
1, 2, 4 and 5, stating in the earlier that he had run that particular machinery, the IMFL shop without permission. And have you mentioned also that you have closed down?
There.
What is your prayer, Mr. Counsel? Huh?
He's not been allowed to operate, my lord. So that is why he has come seeking, come to this honorable court, my lord. And we have said that unauthorizedly they have already tried to run.
But is he operating from his earlier location?
No, my lord, he's not operating.
Are you operating from your earlier location or not?
May I please, your lordship? This case, your honor, has been started as because this IMFL shop was operating at Rajgor Road. Due to road widening, my shop got closed down. So I have applied before the excise authority to allow me to operate from a new site at Bonful Pot, Hatigaon. So after due formalities.
No, formalities first is, have you got the NOC?
Yes, your honor. I'm coming to that NOC. I have produced the NOC and no objection of the municipality also I have produced dated 90.
No, within 75 meters.
Within 75 meters also, your honor, I have submitted the NOC.
Where is that?
Copy of the enforcement order. Local public, annexure 8.
What is this?
Copy of the NOC obtained from the local public dated 14/9/2022. Then, my lord, the deputy superintendent has ordered me to shift my IMFL off shop from Rajgor Road to Bonful Pot. Thereafter, my lord, on 1/9/2022, a complaint before the deputy commissioner was filed by Hatigaon Mohila Samiti Parishad. Against the functioning of my IMFL shop. Upon the order, the superintendent of excise the superintendent of excise ordered me to close down my shop. Verbal order was issued.
So, superintendent, where is your permission to run in the new location? Where is your permission to run in the new location?
Annexure B of the affidavit in opposition.
Annexure?
B.
No, it
Is
is not
90.
there. No, Annexure 5, you don't know.
No.
Yes, what is this? Annexure 5, the deputy commissioner gives him the permission to use the particular area?
Yes, my lord, but
Then you
thereafter,
issue a show cause.
yes,
This was given even prior to, without compliance to 19. Without compliance to 289. This appears to have been given without compliance to 289 and 295. Because of the fact that he got the no objection on 14/9/2022. And he has been permitted by the district commissioner to move earlier
before inquiry.
without an inquiry.
Yes.
Now therefore you have initiated a show cause proceedings. What has happened to the show cause proceedings?
In the show cause notice, my lord, he has been asked to explain, my lord, why he.
Now that I have read it, then what happened?
Then, my lord, it was also found that within the 200 meters, some of the residents were also giving their objection, my lord.
Then, where's your order? Order, whereas the so called, whereas so and so has been passed, was in the name of so and so. Accordingly, it is ordered that the license of so and so presently situated in, if forthwith shifted to any other location that conforms to all the norms regarding the location of a man, or else steps will be taken for closure. Now, have you moved from there? No.
No.
You got a stay of this order.
Yes.
Is a stay?
Yes, whatever.
My lord, see our last document, my lord. In our affidavit, page 120, my lord. This is our observation with regard to the proposed location. Where we finally, my lord, it was said that this is not a suitable location, does not confirm. So he was directed to shift to any other location that conforms to the rules, man.
There is a direction for no coercive measures. But are you still running?
Yes, Your Honor.
No, my lord, his prayer in the repetition is for non-renewal. Why this should not be renewed, my lord? Because it has not been renewed, his license.
Now it has been renewed.
How?
It has been renewed.
When?
2014-24, it was renewed. Your Honor, what happened? After
No,
this,
where is your renewal?
I am yet to file my renewal
Where
here.
is your renewal?
Renewal,
Why you are making that statement of renewal?
the excise authorities has,
You don't know whether it has been doing it or not.
yes, Your Honor, it has been done. I can file it on the next date. I can file it on the next day.
Okay, tomorrow, 2 o'clock. List the matter tomorrow at 2 p.m. On which date? And let the matter tomorrow at 2 p.m. Thereby providing in view of the submission made, specific submission made by the learned counsel for the petitioner, that the petitioner's license have been renewed. The counsel for the petitioner shall produce the renewal of the license of the petitioner tomorrow.
Item 6.
What is this? Matter pertains to what?
Your Honor, this matter pertains to the petitioners who are farmers and having Miadipatta land at village Kotanipur and Bedbari Moja. And they are earning their livelihood through farming only. And in the January 2023, one petitioner, he noticed that APDCL, without their permission and intimation, they were digging pits over the land for the purpose of erecting high voltage electric line. to be connected for Sukapha Multi-Speciality Hospital, Sibsagar. And they have already erected high power transmission lines over the Miadi Patta land, Your Honor. And in the meantime, they have filed objection before the circle officer also. And after submission.
Yes,
of the
Mr.
detailed
P. Chaudhary.
Manoj, we've already filed our affidavit in 2023. Subsequent to the objections raised by the petitioners and other similarly placed individuals, hearing was conducted by the district authority, Manoj, and the APDCL was instructed to remove the erected poles and place them on the place where the right of way was within the APDCL's prerogative, Manoj. That has already been done. Now we have erected those poles. They are no longer existent on the petitioner's plot of land, Manoj. So we stated that in so many words in our affidavit also.
Where?
Yes, ma'am.
Affidavit filed by respond number?
Manoj 5.
Your Honor, some poles are still there.
What?
Your, some poles are still there, electric poles.
Why you are not filing a reply then?
Yes, Your Honor. we will
This
file a-
happened in 2023 and we are in 2025. You were sleeping? Huh?
And two meetings in their affidavit in opposition, two meetings were also held on 6/5/2023 and 11/5/2023.
No, madam. They have categorically said in their affidavit was already being including string of contractors from hospital. The opponent stated that the construction firm here was delayed due to objection raised. According, landowners were given a hearing on 2 occasions, which were held in the office of the so-and-so. Said in the first, it was proposed the corridor would be cleared by dismantling the newly erected so-and-so and so-and-so and so. However, when the work was halted again by some villagers, before this court, a final hearing was held, and during they had to suggest an alternative Yemen. As such, the APDCL agreed to allow the hospital to erect the new poles adjacent to the poles of the existing so-and-so, including were also given assurance by Iman, and the APDCL has also expressed intent to make the interest. Subsequent to the instruction of the construction team resumed the work under the supervision. Respectfully submitted that at that point, at present, all poles that were earlier erected over the disputed corridor of the land have already been dismantled and lifted by the contractor of so-and-so and have been since re-erected adjacent to the existing poles of area as directed by the district administration from Disang to so-and-so. Then thereafter, if you don't file an affidavit, what can I do?
We will file affidavit in 2 weeks' time may be granted, Your Honor. And you may kindly go through.
No, I'm not going through anything. Your grievance was that thereupon there was a hearing, and pursuant to hearing, all these things, new things have happened. You have to come before this court. As per your affidavit, are these poles erected on the petitioner's land? Huh? Where's the affidavit? Page? Page? Now that is of the response number 5.
It should.
Okay, yours starts from later on 68.
68.
What is your stand? The reports reveal it had completed the erection of considerable number of pakas or iman in the land of so-and-so for supplying iman and account to be lying in the field. And says that the public and the owner of the land discuss the complaints and objection down to the case are now. No, one thing, this affidavit is being filed. No, you see, pursuant to a consensus decision, I think this is pertaining to electrical line being high voltage line being taken to some hospital. And that high voltage line was going over the land of these petitioners. Now it's from their affidavit, they say that we have already done it pursuant to some consensus decision. Now, as per your affidavit, does it say so? Where page? #71 para. That thereafter to discuss the complaints and objections and register a case. In the meantime, it is suggested new pole to be erected in between the already existing poles of so-and-so, and we would not face any. In that meeting, the respondent one contractor has agreed to withdraw the elected poles of one and so-and-so. Then what do you say about E? So where is it mentioned that they have carried out again the polls? These are all proposals. Nowhere it is say as proposed. Huh? Leho, Mr. B. Chaudhary, on behalf of PDCL submits that the issue in hand no longer survives, taking into account that after a joint consensus reached between the petitioners, the APDCL authorities, the contractors, and the district administration, the APDCL authorities have erected certain pillars, and have erected the pillars, erected the poles in another plot of land, and the said electricity thereupon have been provided to the hospital in question. It is further seen that this affidavit was filed in the year 2023, and after a lapse of more than 2 years, a lapse of almost 2 years, the petitioner have not filed any affidavit in reply thereto. This court further takes note of that the affidavit filed by the district administration, wherein it is not so clear as to whether the poles now have been erected in such a manner that the petitioners have no objection. Considering the above, this court for the end of justice grants 2 weeks' time to both the petitioner as well as the district administration to bring on record their stand as to what is the present status of the poles in question, for which the petitioners were aggrieved and had approached this court. List this matter on 17th of November 2025 for admission.
Item 7.
Give your name.
With your lordship. My lord, this is for the pending bill, my lord. The Panchayat election 2013, they have submitted, supplied the materials, my lord, but till now the bill has not been given, my lord.
Because till now, no notice has been issued, notice claiming amount, panchayat elections.
Yes, my lord.
Who is to pay?
That is basically, my lord, I supplied to the deputy commissioner, my lord.
Of 2000?
13,
And you are approaching this court in the year 2023.
my lord, my father supplied it. Thereafter, father, after death of my father,
No case, no case. Can't help you.
my lord, my pending dues there to them, my lord.
Where is the admission? Admission is where?
They have submitted quotation against, then I have supplied. it.
Where have you submitted? Where is the
Page
receipt?
annexure 2 is the quotation, my lord.
Huh?
Annexure 2, page
I'm
from
not on
13
that.
onwards. my lord.
I'm not on that, but the fact that you have supplied, they have accepted the goods. Where is it?
Well, and it page
No,
13, my lord.
nothing. No case. 2011, 12, and you are filing in
My lord,
2023.
the department is not paying, my lord. What can I do?
Why on earth you did not approach in 2014
My lord, I approached at that time, my lord.
in the High Court?
Not my lord, to
Huh?
them, my lord.
High Court.
They have served their purpose, their election, they have taken out. When the payment of my is concerned, my lord, they are
Your father
taking the
did
letter.
your lifetime, his
My lord,
lifetime.
even
he
if
didn't
in
want
this
the
case,
money.
my lord, they have not submitted any affidavit stating that I have no case, my lord.
Cannot. They cannot file an affidavit taking into account of that in respect of 2013, they do not have materials. How will they verify? Tell me.
My lord, I have submitted representation. They can
No, your representation you have submitted when?
to 2000.
In 2021.
Yes, my lord.
Why?
Because my dues.
The bills of 2013,
If
you
the-
have submitted
if
the
they do not
representation
pay,
in
my lord.
2021 and then filed the petition in 2023.
Lordship, if they do not pay, what can I do, my lord? Where shall I go?
You can very well file case in 2014 itself. You could have filed case in 2015 itself. You could have filed before the civil court. All these things are permissible. Why after 10 years you are approaching? Where will they find materials? Tell me.
My lord, let me take instruction whether any admitted correspondence is there, my lord.
No, you have no instruction for the last 2 years. No case, dismissed.
I may be allowed to withdraw, my lord, otherwise.
Now I do one thing. I will allow you to withdraw with the liberty to approach the civil court.
Yes, my lord.
Yes.
Otherwise, if I have a claim, my lord, they may be directed. If I have a claim on examination, I may be given.
Mr.
Otherwise,
Counsel, why are you not approaching the civil court in these type of matters? If they are admitting anything, they are not admitting
yes.
anything. Why should we pass an order? There's not a single document out here. No. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Ms. Yudas, who appears on behalf of the respondent number 1, 2, and 4. The petitioner herein has approached this court claiming an amount of rupees 5,72,615 on account of certain supplies which the petitioner claims that his father made during his lifetime in the year 2013, and the same remains unpaid. This court duly takes note of that from the materials on record that the petitioner's father, after materials on record, that though the petitioner claims that his father had made supplies in the year 2013, but there is no materials showing that the respondents have at any stage admitted the said amounts. Ms. Yudas, the learned counsel appearing on behalf of the respondents, further submit that the petition was filed in the year 2023 in respect to claims pertaining to the year 2013, and it becomes very difficult on the part of the respondents to make verification at such late stage. The learned additional senior government advocate further submitted that even the petitioner submitted the representation after a lapse of around 8 years in 2021. Considering the above, it is therefore the opinion of this court that the petitioner is not entitled to seek redressal under the equitable jurisdiction of the court under Article 2 to 6 of the Constitution. Be that as it may, the petitioner is always at liberty to approach the competent civil court if so otherwise permissible under law.
Obliged.
8.
Why no affidavit filed?
Lordship, it's also same, the work order is of 2014, Your Lordship.
Okay, none appears on behalf of the petitioner. Miss Ardeka appears on behalf of the respondents. The learned counsel appearing on behalf of the Water Resource Department submits that it is difficult to file the affidavit, taking into account that the petitioner claims that he had made certain supplies in pursuance to a work order dated 15/12/2014 and have approached this court after almost a decade. It appears before this court that this is not a fit case for exercise of jurisdiction, equitable jurisdiction under Article 2 to 6 of the Constitution, taking into account that the petitioner has approached this court after a lapse of almost 9 years. This court further takes note of that passing any directions in the instant writ petition, thereby directing the respondents herein to make certain verification and net to pay would not be in the interest of justice. Accordingly, this court does not find merit in the instant writ petition for which the writ petition stands closed on dismissal or as being dismissed. Before parting with the record, this court, however, observed that if the petitioner would be at liberty to approach the competent civil court if so advised, and the petitioner shall be at liberty to approach the competent civil court if otherwise permissible under law.
Item 9.
None appears on behalf of the petitioner on call. Mr. S.I. Bolwai appearing on behalf of the respondent submits that taking into account the relief which have been sought for, it appears that the petitioner have lost interest in the instant writ petition. Considering the above, this court therefore closes the instant writ petition on the ground of non-prosecution.
10.
And also it seems to be infructuous now. They are selling some settlement order for the period of 22 and 23. That's all. That's yes.
Lordship, kindly pass over for 10 minutes.
Market is for the 1 year. It has become infructuous.
Yes, Your Lordship, better become infructuous, Your Lordship.
Ms. So-and-so appearing on behalf of the petitioner submits that taking into account that the market in question was settled with the respondent number 7 for a period from 1/7/2023 to 30/6/2024, the instant writ petition has become infructuous. Taking into account the above, the writ petition stands closed as it has become infructuous. So-and-so appears on behalf of respondents. And so-and-so. For private respondent? Yes. Whoever submit, you will be filing wakalatnama on behalf of the during the course of the day. Regarding people. Yes, what is your matter?
Lordship, this pertains to a tender process wherein I had participated in the year 2022. And Lordship, thereafter, the tender process was scrapped off. Eventually, in 2023, it was again freshly instituted, and my tender was rejected on the ground that it was not technically suitable. Lordship, thereafter, I filed representation on 30/6/2023, and it was found that the bid was not technically suitable. After the rejection, the petitioner came to understood that the new bid which was accepted was at a rate which was 60% inflated rate. As in the initial bid, I was the L1 bidder, and the new bid, it was 60%.
So the show cause, you are challenging against the show cause proceedings.
Lordship, against the show cause. I'm onto the fact that the show cause, the authority who has issued the show cause is not the competent authority, and as such, I am before this court. Lordship, as per the Section 46 of the Assam Public Procurement Act, the state government is the one who can issue show cause with regard to blacklisting or debarring me. And my contention is that the authorities.
Is the show cause?
Lordship, the show cause.
Page 119.
Huh?
Page 119, 1191.
Show cause. You have quoted firefighter booths. Clinical quality clarification marks and information.
And Lordship, it is pertinent to mention that this show cause was based on the ground that I had modified my bid, whereas initially my bid was rejected on technical grounds. So Lordship, the respondent authorities are taking two stands.
Your bid was rejected.
Lordship. And
then why are you taking action on this?
But he made some modification. After submission of bid, he made some modification, which is in violation of a particular clause in the JAM.
So JAM, does it say that it will be blacklisted?
Under section 46 of the Assam Public Procurement Act 2017, there is a provision, if he violates the integrity fact, under section 11.
Does it say that if he modifies the bid?
He cannot, it is not allowed.
So if it is not allowed, so you will cancel it. And you have already cancelled this bid.
It is cancelled, but the action of modification during the process of tender, that is the violation of the integrity fact. If someone with a particular specification, offers a particular test.
Then why have you not mentioned that it violates the integrity pact? It doesn't say anything in your show cause. When you issue a show cause, it is in the mandate of law that it has to be clear for other people to understand. Even a judge out here sitting cannot understand that it has any relation with the integrity pact. Tell me, when you are issuing a show cause, you have to say it. Isn't it the mandate of law? That you have to categorically say why you are asking the show cause. This doesn't say anything, show anything to the effect that because of the modification, it affects section so and so, which entirely affects the integrity pact, and therefore you are issuing the show cause for blacklist. Wait, all these things are closed. So on this basis, we should set aside. And what is this? Does this special DGP has the power?
Under 46, the state government and the procuring authority, it is the procuring entity is given the power
To blacklist.
for debarment. The 46 provides debarment
Procurement.
from bidding.
Assam procurement. Kitab khas.
But here,
Section
section 46
46.
of Assam Public Procurement Act 2017.
The rule, yes.
Lordship, may I kindly come here?
A bidder shall be debarred by the state government if he has been convicted of an offence. A bidder barred under subsection shall not be eligible to, if a procuring agent finds that a bidder had breached the code of integrity prescribed in the terms of section 11, it may debar the bidder from a period of not exceeding 3 years. So you are on 46(3).
I'm on 46(3),
Okay, now let's see section 11.
section 11. Section 11,
Sorry, yeah, of the keeping in.
section 11 to Roman 8, can you see, ma'am?
Roman,
Section 11, subsection 2, Roman 8,
Roman
8.
who makes false declaration or providing false information for participation, tender process or secure at tender. But where is it say that you cannot modify? He has not given a false declaration or providing false information for participation, tender process or to secure disclosure of conflict. This has nothing to do.
Well, improper information or well, the making false declaration or providing false information.
For participation. It is not false.
No, why?
He had changed, yes. He must have said that these are the terms, this is the particular boots we are giving. He changed it to another boots. Change it to another boots. Isn't it? As per your notice,
Yes.
see,
Yes.
you have quoted firefighter boots made Harvick model 8687 LS.
LS.
Then it is on record so and so submitted GM portal for raising appeal. And you offered firefighter boots make here number 8687L.
L.
Here that corresponds that the modified bid. What is the difference between both?
Well,
One is LS and one is L.
models are different.
You have modified your bid in between the technical evaluation by modifying the item firefighter so and so to firefighter so and so. Modified during raising appeal. Therefore, your request to so cause, why should they? How do you make this to be a false declaration or false information?
Well, during technical evaluation, if someone keeps on changing the item,
You reject him.
well,
You reject him, but how it will come within this?
well, that is not permissible. Well, we cannot do that.
Understood. For that you reject. But how do you take action under code of integrity?
Well, in fact, these are
It
the
should say, here it should have been mentioned that because you see, debarring is a right under 19(1)(g) being taken away. So you have to be, it is an exception being the provisions of law. So these exceptions, we cannot have this exception in such a broad and wide aspect so that you can have anything. You can tomorrow say that this person looks bad also. So for that we are, at the time he didn't have a, he didn't meet with an accident. After the accident, his face changed. We say that. It is something like that.
the authority has issued the notice and they have
We
to
set
respond
aside
to
this
that.
type of things.
They have to respond to that. No action, final action, final decision has been taken here. Ultimately, when they got the notice, on the ground.
You have, the final action could not be taken because there is a stay.
That's. Chief may kindly see, they do not respond to this notice, only on the ground that.
This stage, Mr. Counsel, the reason is you have allowed this writ petition to be pending before this court for the last 2 years. if it was taken at that point of time, if I was the judge who had taken initially, I would have said that don't take any coercive and ask them to submit a reply. But after keeping the matter pending for last 2 years, does it now look good to say that, okay, go and submit your reply when you have filed your response?
Look, my response for response number 3 is on the way.
No, you have already put your response.
No, we have not.
Whose response is there?
Private response, that's fine.
The gem authorities, Lordship.
Jam has filed, madam. Respondent number 6
So
has
there's
filed.
6, Lordship.
Jam, I appear for Jam, madam.
JAM is not taking any action.
James has said that initially the incident was generated and subsequently it has been closed. So James is not necessarily party here, madam, it has been impeached. The incident which was generated has been closed by James.
So incident report numbers carried out by JAM authorities, that has already been closed. Why it has been closed?
That has been closed because they say that, madam, they have paragraph page 163.
Para?
124, madam. Paragraph 8, madam.
So they say that, okay, if you have any problem, fight it out amongst themselves under clause 16.
160 the page, madam, there has been
One?
160 that clause has been mentioned. 160. One, two, madam, in the event of any conflict of the city arising out of or in connection with the contract.
No, it's okay. That is another thing. You have already closed it. So his prayer at number 3 is become redundant. So only thing, number 3 and number 4 becomes redundant. So only thing is 1 and 2. 1 and 2 is a challenge to the show cause notice. Now you therefore say that this is being done in terms with 46, read with section 11. And you say that it falls under 8. 11 to 8. 2A8. Let me hold it. Let him file a reply. But I will hold it that 11 to 8 does not fall.
But in fact,
Because you cannot do that. I say that nothing is there
section
on which you could have taken such an action. However, allow him to submit for you to close it.
but section 11 is there.
No, 11 does not come out. No.
But
This
my
is a case for
my affidavit for the respondent number 3, they are filing it. I'm trying to file it.
You are allowing this so-called proceedings, so now would it be fair?
No, on the ground of jurisdiction, they have challenged this. And the
Jurisdiction for the last 2 years, you have not been able to do anything. Are you the procuring entity?
yes,
Let us see who is the procuring entity.
for the respondent number 3, I'm
Who has issued the notice
the
inviting tender?
DSP.
Procuring entity is who? Department of Home and Political Department. Office on Fire and Emergency Service. Item so and so, jacket, trousers, helmets, so and so. Show me one term in the contract which says that you cannot modify your bid, the item. You have not submitted, filed your reply, that also good grounds. No reply filed. On that ground, we have hold it back.
Kindly come to page 42. my lord.
Yes.
Page 42. 19.15. I'm just,
Earnest money, 3% of the value to be deposited in the form of Iman or Iman in the form of Iman. The earnest money of the security is to remain valid for 45 days beyond the final bid validity will absence. The earnest money of the year will be returned to him at the earliest after the expiry of the and for the those bidders registered with central government are exempted from the cost. So how is it relevant?
the Director of Fire and Emergency Services, they are the procuring authority. I'm not showing that.
Huh?
The Director of Fire and Emergency Services Assam, they are the procuring authority in the deed.
No, it's okay.
No,
Let us go. The reason for which the interim order was passed was wrong. Show me that he cannot modify his term.
but kindly give me 2 days time. my lord. Today I'm
You have
trying
not filed the affidavit.
today I'm trying to file the affidavit. my lord.
No, you have not filed the affidavit.
No, we'll file.
You have not.
No, I have already sent. my lord. Today I'm
Okay,
trying to
we'll
file.
take it up at 2. And file your affidavit.
Kindly take it up
No,
tomorrow.
2.
Tomorrow.
2 o'clock. This time of a thing where you have not filed an affidavit, you want to file an affidavit, this is it. You seem to be not interested. Or let us admit the petition, let it adjourn, sign it there. You have the interim order, keep it
Lordship.
there. Adjourn, sign it there.
I give no 1 day time. If
No,
not, tomorrow. my lord.
It is seen that the respondents, in spite of various opportunities being granted, have not filed the affidavit. So, taking into account the above, it seems that the respondents are least interested in spite of there being an interim order. Accordingly, matters stands adjourned to be listed after 6 weeks. Interim order passed earlier shall continue till the disposal of the writ petition. It is observed if the respondents in the meantime do not file the affidavit, this court shall take up the writ petition for disposal.
We have filed, my lord. That may be. Please.
Take up the disposal. On the basis of the materials already available, including the affidavit filed by the JIM.
May please, Lordship. Presently, my lord, as per my instruction, my lord, this mall has been abolished, my lord. As per our verbal instruction, my lord. So my lament may obtain, my lord.
Police. Yours.
And the state, my lord, is transferred there.
BDC will.
I will have to obtain instruction to that effect.
Has been submitted by Mr. So-and-so, the learned
Yes, sir,
counsel
Ahmed.
appearing on behalf of the petition. That the Mohol in question, that is Vishu Basra Mohol, under Koragat range or Bat PARDATJHORA Forest Division have been abolished
Yes. And merge with another mall, my lord.
and merged with another Mohol. The learned counsel therefore submits that a cause of action for which the petitioner had approached this court no longer survives. Considering the above, the writ petition therefore stands closed. As infructuous, the interim orders passed earlier stands vacated.
Obliged.
14.
Copy আছে? I got two. I got two. What? পইচাটো দিব লাগিব নহয়।
What do you mean?
My lord, my vehicle was detained without issuing any seizure memo. Thereafter, the petitioner filed the writ petition before this honorable court. And then the authority, the officer in charge of the Khalan police station released the vehicle. Now, in the writ petition, I pray before you or this honorable court that since my vehicle was detained without issuing any seizure memo or any other lawful means, so I should be allowed to compensate. That is my prayer.
Go before the civil court. Go before the civil court. You have better things to do.
My lord, 9 months, 29 days, my vehicle was stranded before the Gumla, in front of Gumla police outpost. And it is financed by the finance company, my lord.
Oh, before the civil court, seek for damages.
My lord-
Yeah, how will we know that it was 9 months? You took the
My lord,
vehicle
my lord, on
on 21/4.
yes,
Then
my vehicle was released on 21/4/2024. It was detained on 21/3/2023, 6/2023.
and the vehicle's chassis number and engine number were.
My lord, if my vehicle, I should be convicted. I am ready to face the consequence. I am ready to face the consequence.
Did you apply for Jimma? Before
Yes,
the court?
it was given on Jimma.
Before the court.
My lord, while filing, after filing of the affidavit in opposition by the respondent authority,
No.
the
Your
officer
Your vehicle was seized, taken
Yeah.
away.
it was not seized by me. It was not seized. That is why, my lord, kindly have a look of my page number 32. Annexure 3 of my affidavit in reply. This was issued by the officer in charge Khalan police station in favor of the petitioner.
Then
My vehicle was not parked by me, it was taken by the police. That is the difficulties. Around 100 of vehicles are there, my lord. Battle net vehicle. In the foreign metal nut vehicle, but in my vehicle, my lord, there is no foreign metal nut. It is local made for metal nut. And the question, allegation brought that my chassis number was defaced. If it is, then let the authority file an affidavit and give reply. No such reply was given in respect of this. No such inquiry report was submitted. And I faced a lot of financial problem for giving payment of monthly installment of my vehicle.
Can you come to page 26?
My lord,
Page 26.
yes, my lord.
What is this? Remarks?
My lord, if it is so, with utmost respect, my lord, if it is so, then my vehicle, why it was released? It was not seized.
Okay, we asked them to confiscate your vehicle. You surrender the vehicle before the authority. You can surrender the vehicle back to the authority.
My lord.
No, you are now questioning why it should have been released. So you surrender the vehicle.
My lord,
No, it is defaced. This is defaced at page 26.
My lord, vehicle chassis is manipulated to the time at the time of authority, my lord.
Examination.
Examination.
Yes.
My lord, this vehicle, thereafter, my lord, this notice came, my lord. Kindly have a look. Page 32. Thereafter, this notice came.
Yes.
This officer in charge has given notice to the petitioner
Yes.
to take the vehicle. Accordingly, I took the vehicle.
Yes. Then?
What wrong I have committed, my lord?
No, they tried to communicate you many times, but you have not come. That is also
My
there.
lord, I have stated in my writ petition.
But they have stated, if,
My lord, I have
Mr. Talukdar, if you are relying on page 32,
Yeah.
it cannot be relied only in parts, that this part is where I'm relying, I'm not relying on the other part.
No,
The contents of the document has to be said to be good, it has to be good for all or not at all.
My lord, kindly think about the position. I approached, I have.
Therefore, I am saying go before the civil court, prove all these things.
Yes, let it be.
Yes. If 32 says, my lord, he did not cooperate with the police.
Mr. I. Talukdar, the learned counsel appearing on behalf of the petitioner, and Ms. Udas, who appears on behalf of the respondent. The petitioner herein have sought for release of his vehicle, which was taken into custody in Kalayan police station, and also sought for adequate compensation. It is seen from the records, and to which the petitioner duly admits, that the petitioner had taken the Jimma of the vehicle on 21/4/2024. So, under such circumstances, the first part of the relief which have been sought for by the petitioner have been duly redressed, stands duly redressed. Insofar as the second relief so sought for as regards adequate compensation, it is seen from the materials on record, more particularly the pleadings as well as the documents enclosed hereto, enclosed to the said pleadings, that there are disputed questions of facts as to whether the vehicle having been kept in custody was in accordance with law, and also whether the petitioner was duly given information to get the vehicle. Though the petitioner herein relies upon the annexure 3 to the affidavit in reply. But the said document, which have been written by the officer in charge of the Kalan police station, also shows that the petitioner were duly intimated to take back the vehicle and the petition, and by producing the necessary documents, which the petitioner failed to do so. Considering that there are disputed questions of facts which can only be adjudicated in a forum wherein evidence can be led, it is the opinion of this court that a case for grant of an compensation as a constitutional tort does not arise in the present facts. However, if the petitioner is otherwise aggrieved by the loss sustained on account of the actions on the part of the respondent authorities, the petitioner would be at liberty to approach the competent civil court seeking redressal, seeking damages for the loss sustained by the petitioner. It is observed that the period from 16/10/2023 till date be excluded while computing the period of limitation.
My lord, 23/6. It was, the vehicle was detained on 23/6.
Mr. Counsel, you have filed a petition on 16/10/2023.
Yes, my lord.
We are in 2025.
Yes.
So 16/10 till today has to
Yes,
be
yes.
excluded.
I have
Otherwise, you
respect
have
to
a
that.
problem with the limitation.
Item 16.
First, this matter is pertaining to the non-releasing of performance security money to the petitioner by the respondent number 4.
Yeah, why have you not released?
But see, what happened, there are some defects of the work and they have to rectify them. After rectifying them, we will release the amount. It is fixed deposited in the bank, lordship. It is deposited in the bank, lordship. And after rectifying the defects, lordship, we will release the same.
Has it rectified?
No, they have not rectified yet. We have communicated several times verbally.
Where's the affidavit?
File application application, lordship.
And what is your reply?
At page number 5, page number 37 of affidavit in reply. Lordship, kindly see the work order, Lordship. Lordship, it starts from paragraph number 5 of affidavit in reply.
Where is your no defect liability certificate?
Lordship, they have not provided us no defect liability certificate, Lordship. Lordship, the respondent.
So here it says the performance security will be returned to the contract after completion of the defect liability and against submission of no defect liability certificate.
Yes,
They
Lordship.
categorically say that the work still remains in a defective stage.
No, Lordship, kindly see the work order, Lordship, at page number 15 of the petition, annexure 1, Lordship.
Lordship, condition number 4, clause C. Lordship, here it is stated that the defect liability period is 180 days for a full rainy season.
You go to the defect liability period after you provide a no defect work to or hand over a no defect work to the petitioner, respondents.
Lordship,
And against that, you have to get a no defect certificate.
Lordship, it is their duty to provide us a no defect liability certificate.
Then,
Lordship, on
when did you ask for no defect liability certificate? Show me.
Lordship, we have handed over the construction work on 1/2/2022. Lordship, annexer to page number 19. We have completed the work on Lordship 31/1/2022 and handed over to them on 1/2/2022. And Lordship, 180 days is over on, no defect liability period is over on 31/7/2000. 31/7/2022, Lordship. Lordship, within that period, they have not communicated us, and they have not stated us about the there is defect, and there is certain defect. They have not contacted us about that, and they have not stated us they have not sent us any notice, Lordship. And then, Lordship, when the period is over, we have filed 3 applications, Lordship. That is, Lordship, on Annexure 3, page number 21. On first application was sent on 1/8/2022. Second application sent was 5/9/2022, and third application was sent on 10/10/2022. But they have not give us any reply to that, Lordship.
What do you say about this one, page 33?
Lordship,
33 is the email.
Lordship, email, they have sent us an email. And the date of email was, Lordship, September 18, first email was sent on September 18, 2022, which was 2 months later from the expiry of the limit no defect liability period. 180 days was over on 31/7/2022, and they have sent us email on 18 September 2022. They have to send us if there is any defect. They have to send us before 180 days, Lordship, as per the conditions of the work order.
Lordship, there is another part in the said paragraph, Lordship. For a full rainy season, whichever occurs later, Lordship. 180 days or a full rainy season, whichever occur later from the date of handover of the construction asset, Lordship. In generally, Lordship, the rainy seasons occur on October, Lordship, as per my knowledge, Lordship.
No case. Go before civil court.
Lordship, already rainy season, it started from Lordship April. Then we have completed our.
Rainy season doesn't start. Rainy season starts later on.
Yes, already we have
Rainy
completed
season
the work.
starts from the month of June, when you have the monsoon.
Lordship, we have already
And it
completed the
ends
work.
sometime in the month of September. You see, for this court to decide these facts would be very difficult.
Yes, Lordship.
Because they categorically say, because you see, question of this court has to now say that the defect liability certificate
Yes.
is not necessary. Because you have never asked for a defect liability certificate, which is a mandate of clause 5. No defect certificate, where is it?
They have not provided us, Lordship.
Understood, but
Yes.
where did you ask? You never asked for that.
Lordship,
Kindly fix it. Actually, I am appearing on behalf of M. Kolita. He is out of station. Kindly fix it at that short period. Yes, Lordship, actually, I am appearing on behalf of M. Kolita. He is out of station. So kindly fix it at least give me a chance at least.
The request of the General Council for the petitioner matter stands adjourned to be listed on third Friday, date of August.
17 and 18.
Wait, please, my lords. Because I'm praying for some time, my lords. My lords had directed us to obtain us certain instructions from the APDCL, my lord, with regard to a proceeding before an appellate authority. Once I am yet to receive that order, if my lord kindly grants me 2 days' time, I'll obtain the order.
Oh, that one.
Yes, my lord. Because the order of the ARC was thereafter, my lords, the matter was relegated to the appellate authority. The appellate authority's order perhaps will be relevant, my lords.
My lord, by the order dated 24/7, my lord, my learned friend was directed also to take instruction regarding to 1C. 1C.
I'm asking for you for a very simple thing.
Yes, my lord.
What do you mean by the word substitute? What was the law, which was the provision of 7.4.2 Roman 3 prior to that?
Yes, pre-amendment.
Does it take for you to get this thing
Well,
in session after almost 2 months?
No, but that I have, my lords, but they are also placing reliance on an order passed by the ARC with regard to a meter, my lord. That is part of the petition also, my lords.
My lord, may I
Now
speak, my lord?
that order, my lord,
My lord, the clause 7.4.2 1C is important, my lord. Then others come, because my lord, as my learned friends stated, my lord, the 7.4.23 come notified later on, my lord. But that is also relevant because, my lord, the
Now,
reason,
therefore, I saw
my lord,
when the word is being shown as substituted,
Yes,
means
sir.
there was a pre-existing condition, provision.
Yes.
my lord, I am not on that, my lord. 7.4.2 1C is there, my lord, prior amendment, my lord. 7.4.2 Roman 1C is existed prior to the amendment.
But we are concerned with 7.4.2 Roman 3.
That is reflected in the last order, but my lord, by the order dated, my lord, 24/7/25, my lord, directed my learned friend to take instruction in both the clauses, my lord. My lord, I have a
Yes.
notification, my lord, originally.
As well as so and so have been followed. No, that is okay. Then on the next day, he came up with this thing that this particular provisions only came in 2019.
That is only 3, my lord, not 1C. My lord, I have original notification, my lord.
One,
7.4.2
one.
Roman
three.
1C.
If the assessing officer suspects the unauthorized use of electrical and frequently in excess of the electronic will be the install. The both terms are surrounded. So this was there.
Yes, my lord. It was there. And also, my lord, what have amended is arises from the ambiguity existed prior to that, my lord, in this notification, my lord. When, my lord, the Simpex has raised this issue, then the AERC came to know about the ambiguity and
It has to
according.
be done as per electronically, na?
Yes,
As
your
per
lord.
Your was an electronic meter.
Yes, my lord, MDI meter.
And 7.4.2 here, in case of MDI meter.
Yes, your lord. Actually, that is specifically mentioned. Otherwise, also, my lord, the reason behind this came to light, my lord, interpreting the 2.3.3, my lord, and 7.4.
But these 7.4.3, 4.2, Roman 3A, capital B, capital A, small b,
Notified letter
would not apply to you.
directly, my lord, directly not applied.
Would not apply to you, taking into account that that was not a provision at that point of time.
Yes, my lord, that was not that there.
That
my
was
lord.
not there.
Yes,
But
my lord.
this particular provision was there, 7.4.2.
Roman 1C is there.
And this continued to remain the same.
Same, my lord.
So therefore, I put that question to him on the last occasion. A and B would not have been applied, taking into account that the assessment is for the year and there was an amendment made so and so. So this was shown as substituted.
Regarding 3.
So it transpired that here was substituted. The word substituted means there has to be, prior to that, there was something else. 7.2.
There is only the calculation given, my lord.
Method or assessment, demand B. So this is there.
Yes, your lord.
So now we have this. So if it is a case for provisional as was so and so, this remains the same. 7.4.2, 4.2, Roman 1, C.
Yes, your lord.
That remains the same.
Remains the same.
So then, if it is an electronic meter are installed and the load curves are studied periodically, the period of unauthorized use of electricity could be limited to the exact period as to be determined scientifically. Have you taken any steps in that?
My lord, would kindly give me 2 days time. I'll come back with this.
My lord, in fact.
Also, my lord.
In fact, that period, my lord, whenever excess consumption has been done by the petitioner, my lord, the APDCL authority has imposed penalty, my lord. I have annexed the bill, my lord. My lord, what have been raised by the APDCL authority at page 79 of item number 18, my lord, where it has been mentioned about the overdwell penalty, my lord. If the penalty has already been made, my lord, subsequent assessment is, my lord, double jeopardy comes, my lord.
Okay, let me give him 2 days time and finish it out. Can be, and it is being shown as part heard.
Yes.
It shouldn't be any further. Anyways, Mr. B. Chaudhary appearing on, Mr. M. Soike appearing on behalf of the petitioner has placed before this court the electricity supply code and related matter regulation 2004 as was notified by the notification dated 6/11/2017. Full stop. Under
Malad
such
regulation
circumstances, this court, this court have duly perused the said regulations of 2004 as it stood.
My lord, regulation 2017. Sorry.
Understood. It is 2004. Oh, okay. Have placed before this court the Assam State Electricity Regulatory Commissioner. What is the name? Assam Regulatory, what is the name? Assam Electricity Regulatory Commission bracket Electricity Supply Code bracket Regulation 2017 as notified by the notification dated 6/11/2017. Therefore, upon perusal of the same, it appears that clause 7.4.2 bracket Roman 1 bracket C was in existence prior to the amending regulations of 2019. And taking into account that the inspection in question took place, assessment in question was for the year 2018. This court therefore, taking into account the specific stand of the petitioner that the meter in question was an electronic meter, inquired as to whether the provisions of clause 7.4.2 bracket Roman 1 bracket C of the regulations of 2017 as was in existence at the time during the period of assessment was followed. Mr. B. Chaudhary submits that he requires 2 days time to obtain that instruction. List this matter on 4th of November, on 6th of November, 2025.
6th of November, 4th if possible. 6th and 7th might have some difficult.
Okay, on 4th of November, 2025.
अब लग जाएगा।
ठीक है।
19.
My lord, the non-payment of contractual bill, my lord, last occasion for instruction for whether my lord petitioner is entitled or not.
Where is Mr. S.R. Burua?
The report has come. Just refer to that, my lord, order which the petitioner has annexed in the petition.
Which one?
One Roman. I did a field, my lord, 39. Rajan Kumata. Relevant is 46 para 17.
Yes, Varun.
The claim otherwise is of 2003-4. Now they have closed it. Amount is 4,82,000.
That is understood, but you have to also take note of the order passed by Justice Rishikesh.
That was to a different aspect, like another contractor. Where my
It
lord,
is in respect to the same contract.
no, not the same contract.
My scheme is
Scheme
same.
is same. Scheme is same.
No, in the same scheme.
Yes.
You see, from the report which I could see from the executive engineer,
My lord.
it is seen that the two works for which the petitioner has approached this court are the works for which one Mr. Arkadas claimed. The court directed for release of this 1,06,00,000 or something, subject to furnishing of the bank guarantee.
My lord.
Now, did you make any inquiry pursuant thereto?
No, here, my
Because
lord.
your stand.
No, this is not the stand of the department that, my lord, so far as the present petitioner's works are concerned, it is within the 111 number of works which was claimed by Arkadas. That's not the case. Apart from that, my lord, some 86 claims were there, works were there, including the petitioner here. That is the last paragraph. So, my lord, for this, my lord, dispute probably, my lord, the entire, my lord, no money was released, and my lord, probably by 2025 year, my lord, it has got lapsed. In 2012, some amount
No,
was
no, no,
sanctioned.
there was a direction being passed by the High Court
Last year.
for releasing the money to Mr. Arkadas.
Yes.
Did you release it? You must
No,
have
it was not released, my lord.
Did
Lord,
you
we will
file
see
an
the-
appeal there against?
Now, Lord, we will see, my lord, what the section says. Order is there, therefore, to balance the equity interest of both sides and taking into account that the government has sanctioned 1,06,77,807 for making payment to the petitioner, and this fund is kept intact through interim order dated so subject to furnishing of bank guarantee from a scheduled bank by the contractor. The earmarked amount of is ordered to be released to the petitioner. However, the department authorities are given the liberty to encase the bank guarantee if any adverse finding is reported against the petitioner through a legally acceptable process, including the verdict. In the criminal case, it is ordered accordingly.
So therefore, there was a direction to release to Arkadas. So you must have
That will
released
be
it
done-
subject
that
to
will be
payment
done
of
by
a
the Water
bank
Resource
guarantee.
Department.
Huh?
That will be done by the Water Resource Department. Not with the town.
Now, for whom are you appealing?
For respondent number, my lord, 4, the deputy commissioner was, my lord, directed to have an inquiry and to place the report. Pursuant to that,
Regarding?
on this point, man. The last order, my lord.
No, everything is understood. But is this particular amount which the petitioner claiming not part of that what Mr. Arkadas has claimed?
Lordship will see the first page, madam. That reply is there in that instruction I have placed. First page. The third para, following the completion of the scheme, Arkadas, a contractor, has received a total of so and so. Approach the honorable court with forged documents claiming so and so. Upon scrutiny on no valid bills supported by measurement books and other necessary documents were found in the office record to substantiate Arkadas' claim, except for the 2 genuine bills. Consequently, payment to Arkadas could not be made as it would have violated standard procedure in accordance with the final order of the Honorable Guwahati High Court. As a result, pending bill amount of so against.
Because Mr. Gogoi, can you appreciate?
My lord.
Earlier, the stand of the state was categorical before Justice Rishikesh Roy.
My lord.
State stand was,
My lord.
then look here, all these contractors are entitled to. But because of that petitioner therein, who have committed this fraud, the forgery, they have been deprived. And you see the submissions made by the state. And you come to paragraph 13, page 44.
13.
Yes. Page 44.
Yes.
When we take into account the liable convention, the execution of the flood damage repairing work on the left event of the Islam River is found to be uncontested, but the respondent raises the petitioner's claim for contractual use by projecting that those 111 works so were executed by a group of contractors and they are suffering for non-receipt of their use for the executed works. When we
So
say-
therefore, your stand was that these petitioners, including them, were duly performing. So therefore, when the court directed you to release 1.6 crores, 1.06 crores to that Mr. Arkeda, you must have released it.
Oh, here it says, my lord, not released, that infraction went that way.
So the order passed by this court have not been complied with. Did you file an appeal there against?
No.
Anyways, so if you have not released it, have you made Mr. Arkedas a party here?
No, man.
How can this go? Because there is a cross claim made by Arkedas in respect to your amount.
My lord, there was a my lord letter issued by the my lord executive engineer, my lord, page 55, my lord, can you see, my lord? Page 55, my lord. Letter dated 29/9/2021. And 56, my lord. Otherwise, my lord, executive engineer admitted that, my lord, that this present petitioner is a genuine contractor, my lord, he is a, my lord. Page 56, last para, my lord.
Yes.
This remains the same since 2020. No, therefore, the question is,
The due is, my lord, 4,33,000. If they admit it, they also.
as of now, you are admitting.
Is there-
But the fact remains that he has paid it. And what do you say? What are the source?
The same, my lord, because of the order of.
No,
the-
the question is, did you make that payment of 1.6?
No, Lordship. Not. Payment is not paid.
To that Arkedas you didn't pay.
Uh,
That means you had the money with you.
yes, your lordship.
When there was a specific direction passed by this court, why didn't you pay? Or did the Arkedas did not provide the bank guarantee?
That may be the.
No,
condition
find
of-
out that. Because once we find out that, then the question will be there. Because you see, I direct you to pay his amount, which you admit that he is entitled to if I direct you. Wouldn't that be contradictory to what the stand has been taken by the learned coordinate bench? That is why the question is, was Arkedas made a party? Because Arkedas claims this amount which the petitioner claims to be entitled to.
Yes. But, Lordship, the whole amount, the honorable court has stated about the whole amount, your lordship.
Understood. That was 111 claims.
Yes.
Of these 111 claims, the total was 1.06 crores.
Yes, your lordship.
The court directed you to make the payment
Yes,
subject to giving the bank guarantee.
bank guarantee, your lordship.
Now, you say that payment has not been made.
Not paid.
Why the payment has not been made? That is one reason.
Page 56, the reply is there, the Arkedas never approached the office of, the authorities. That's
To
why
submit the bank guarantee.
Maybe, but it's very clear, madam, from this paragraph.
Because we need, because this will, if the moment I pass an order here, it will start
Yeah.
litigation for remaining other,
Yes.
this is only 68 lakhs. The remaining amount, all these people will start coming. So therefore, I need to make it clear to the effect that he did not approach.
So
So
that
put it
was,
on-
yeah, page 56, not say again, 56.
Ah.
The first para,
Ah.
first para, last para. It is known from the office employees of this office that the Arkedas did not appear in this office after that. After logging of the police complaint, madam, he is not there. But because of no bank guarantee.
There may be the confusion because no bank guarantee.
Let
He
us
has
not go on the basis of
Yes,
hunches.
your lord.
Instead of that, let us go on the basis of some affidavit
Yes.
as to
Yes.
whether the payment was made
Right.
and if not made, why? You give us, means he may not have claimed thereafter.
Madam.
then I can say that that was subject to this, and he must have waived or whatever may be.
Yes, Your Lordship, I will take the definite instruction, whether what happened actually, Your Lordship, and allow me some time.
Better you do that. It is seen upon hearing the matter, this court heard the learned counsels appearing on behalf of the parties at length. From a perusal of the materials in the court, it is seen that the petitioner herein claims an amount of rupees 4 lakhs, 5 lakhs or 1.
4,82,214, my lord.
4,82,214 against works carried out falling within the scheme pertaining to scheme under FDR head for the year 2003-4 and 2004-5 pertaining to Sibsagar END division. The record further reveals that one Arcadis had earlier filed a petition which was registered and numbered as WPC number 5181/2011 and claiming inter alia that the said Arcadias was allotted various contracts, including the contracts which were awarded to the petitioners at a total estimated price of rupees 1,06,77,807. The record further reveals that on 10/12/2015, this court did not disbelieve the stand of the respondents that the contracts so awarded to Arcadis, that the claim of the Arcadis was fraudulent. And therefore directed the respondents in the water source department to release the amount of rupees 1,06,77,807 subject to the said Arcadis providing a bank guarantee of the said amount. This court further, in the said order dated 10/12/2025, observe that in the circumstance it is found later that a claim of the said Arcadis was legally not acceptable, was a fraudulent claim by way of a legally acceptable process, including the verdict in the criminal case, the said bank guarantee could have been encashed. This court further takes note of that pursuant to directions passed by this court in the present writ proceedings, an inquiry report has been submitted by the Additional District Commissioner Sibsagar, wherein it has been duly admitted that the petitioner have performed the said part of have duly performed the work in question and was entitled to the amount as claimed. However, it was mentioned that on account of the order passed by this court on 10/12/2015 in WPC number 5181 oblique 2011, along with the petitioner, various other contractors have not been paid their dues amounting to rupees 65,49,636. Under such circumstances, this court fixes this matter on 19th of November 2025. In the meantime, the Water Resource Department is directed to place before this court by way of an affidavit as to whether any amount was paid to Mr. R.K. Das pursuant to the directions passed by this court in the order dated 10/12/2000 so and so in WPC number 5181 oblique 2011. And as to whether there was any further inquiry carried out as regards the claims of Sri R.K. Das. List accordingly.
20.
Yes, Mr.
Description of repeat incident and this one finally is completed. It's 2 weeks. We file an application.
They are asking 2 weeks time, my lord.
I kept the question of delay and latches open. This is of 2009, 10 and 12, 13.
My lord,
Why shouldn't I dismiss it?
but I have filed this writ petition, my lord, because, my lord, there is a communication from the government that is at page 61, my lord, on 2025, my lord, 3/5/2025, my lord. Here,
Communication by the government dated page
page 61, my lord.
61. Enclosed, please herein as received from.
In terms of
we
my-
have for your information and requested you to take necessary with the council of clearance of the pending matter. So,
Clearance pending,
what is enclosed? Enclosure is what?
enclosure for regarding my payment of bills, my lord, in respect
So-
of my letter dated page 59, my lord. And I have been approaching, my lord,
Who appears for the PHE?
and subsequently another letter, my lord, also found, my lord, for fund demand. for
Where is
pen-
the admission?
Admission is at page, my lord, your lordship, page 45, your lordship found.
Huh?
Start from page 45, my lord. This is the 11 series, my lord. This
What is the
just-
date?
Date is not, in fact, there, my lord.
Well,
But
how do
they
you
have,
know the validity of these documents?
that is the signature of the executive engineer, and they can, one, in page 47, your lordship may found, date is 26/3/2021, page 47.
These have been given in the year 2021
Yes, my lord.
by the
26
executive engineer.
The executive engineer.
You cannot do this.
He is the best person, he may clarify this.
No, no, no.
Yes.
How will he know?
Secondly, my lord, completion certificate is also there. I have annexed. Work completion certificate I have annexed, my lord, from, that is page 10 series, my lord. Yeah, page 38 onwards, my lord.
Yes, madam. You are appearing for the executive engineer.
Yes, okay, on the-
Amran Division. He has the audacity to give a certificate saying that he has the petitioner is entitled to. On what basis has he made the verification in the year 2021? That without the date and all this thing. In respect claims made in the year of works done in the year 2009-10. Okay, we get the instructions tomorrow. Ask the executive engineer to be present in the video conferencing more. Because this is not how you do it. They should not be in such a casual manner giving these certificates. They have not made any verification. It is not in a letterhead. Is this the manner in which the executive engineer gives? There is no memo number, nothing. And this type of matters, this is how you give certificates. Yes, Mr. Additional Advocate General, Finance. How are these certificates given like this? Every time I get this, these are of the year 2009-10. These people give on certificates in the year 2021. Like, see page 46, not even a date.
Work order relates to 2012, my lord.
2012, then also in 2021, how is he giving?
My lord.
No pad, nothing. Is this the way? And see, and then look at this, all these things. On one day, this particular engineer gives the certificate for everybody. Who was this engineer?
And he also
How the state government along with your departments
work
function?
completion certificate is also there, my lord.
What?
Work completion certificate.
Work completion certificate given in the year 2021. That's all. Of the year
No, no, my lord,
2009,
My lord,
9
yeah, it's
work.
not there, my lord.
This is being given by the same date. See, I wish him success. See, all these given by the same person. Same date. I think this is a case for issuance of a CID inquiry. What do you think? CID inquiry. Let us issue a CID inquiry. As a judge, I have not issued any CID inquiry. So let me do the honors of doing it for the first time.
But this
No,
certificates.
no.
No.
You go before the civil court. I give you time. I'm not going to allow this type of matters. They have admitted file summary suits. But I cannot permit these type of things to be done in this manner. See here, mission director. Kindly see page 57, the mission director. You are appear for this mission director, page 57. These are works under you. With respect to the Iman, I would like to bring to your kind the enclosed list of bills are pending for payment as well, so and so. I'm not. But here the mission director thing is not transferred.
Then in page 22 also.
Sir, after so many works done, so and so. These are the bills which are being there.
Page 22 also, your 58 also, your lordship.
Yeah. Why the mission director has not been made a party? You made him a party. These are same date, something, and one fine more.
Jal Jeevan Mission, Shamhangawadi.
Page 58 also, there is one communication.
58 is also communication from the chief
It is
engineer.
being given by you. This is JJM, not yours, na?
Under PSU.
And none appears for the PHE. Chala. When a matter is called, none has appeared on behalf of the chief engineer, PHE, who is a party to the instant proceedings. On behalf of the respondent number 1 and 2. 1, 2, and 5. Whereas the council appearing on behalf of the Karbi Anglong Autonomous Council 6 for time in respect to the other respondents. It is seen from the materials on record that the petitioner herein petitioner claims that he was awarded on work orders in the year 2009-10. and 2011-12. And against these work orders, the executive engineer, who is the respondent number 7, had given work completion certificate in the year, sometime in the year 2021, and have also endorsed the bills, have also certified that the petitioner is entitled to the amounts. It is not known on what basis such verifications were carried out in the year 2021. It further surprises this court the manner in which the certification is being done by the respondent number 7 as regards the amounts payable to the petitioner. Taking into account that none has appeared on behalf of the, taking into account that the amounts concerned are claims made in the claims made, which are to be paid from the public exchequer. And the PHE department has not represented. This court, therefore, directs the Commissioner and Secretary to the Government of Assam Public. It will be the Additional Chief Secretary, no? PHE is Additional Chief Secretary or Public?
Special Chief Secretary. Special Chief Secretary.
The directs the Commissioner and Secretary, Special Secretary to the Government of Assam PHE Department, come Mission Director Jal Jeevan Mission Dispute, who is the respondent number 2, to appear before this court through a video conferencing link to be provided by the Standing Council of the PHE Department on 10th of November 2025. At 10:30 a.m. to provide, to apprise, so that he may in a position to apprise this court as to such type of certification can be allowed
Item 52, step 2.
Matt, please.
Yes.
My lord, technical, which starts from my lord.
What is your case?
My case is cancellation of the tender, my lord. Yes, I have, after financial bid, the petitioner stood L1, my lord, and his technical bid was found responsive, my lord. Thereafter, financial bid opened and his bid was found responsive, my lord. He stood L1, my lord. That is, your lordship may found at page 40, my lord. Page 39 and 40, my lord.
But there was a notice to proceed with the work.
No, my lord. It is yet to be started.
Huh?
Yet to be issued, my lord. In the meantime, they have cancelled the tender, my lord, on technical reasons.
Where?
Cancellation order, your lordship may found it. Page 49, my lord, annexure 15.
Why you are challenging it?
My lord?
Why you are challenging it?
My lord, because my lord, technical reasons, there is nothing mentioned about the, what is the technical reason. Since my technical bid is been found responsive, thereafter they have cancelled the tender, entire tender, my lord, for technical reasons. That is
Due
your
to
lordship,
administrative reasons.
my technical reasons. Page 49 is the cancellation order, my lord, and then they have also issued the retender notice, my lord, at page 51.
So you were the highest bidder,
Yes, my lord.
lowest bidder.
L1, my lord, that is page 40, my lord. Annexure 7. That is measures, petitioner is measures infra and Projects Limited, my lord, that is 2 crore 51 lakhs 84,439. And second bidder is 2 crore 60 lakhs 56,100. And
So did you submit the details pertaining to your existing work?
my lord, one work I have submitted in my tender, that is space 221. my
How
lord,
many
that I given-
works were there?
And another, my lord, I have given the reason, my lord, to written reply, my lord, that is page 42, my lord. Wherein I have submitted that that work is yet to be started and project site is yet to be handed over to me, my lord. So there is an uncertainty
It's a
is there.
different thing, but you have been issued a notice inviting and proceed with the work.
No, my lord, yet to be issued, my lord, proceed with the work. And in respect of that work.
No,
which-
no, in the second work.
Second work, my lord, they have issued the proceed with the work, but work site has not been handed over to me.
That is not relevant. How are you going to assess the bid capacity? Unless you point out that aspect.
My lord, yes, my lord.
Kindly come to page 75. Isn't that the case?
Clause 4.4.
In fact, Mr. Gogoi, I thought about it, that matter.
Yes, tomorrow it is coming.
There also, it is required to interfere for the purpose. Because in another matter, what has happened, it was a small matter, it's a different aspect of the matter. If this court holds that this is permissible, not mentioning it can be looked into later, this judgment will impact you in other matters, like this matter.
Yes.
You can very well say that what you said in that case was, okay, we looked into then also he had the available bid.
And my lord, it was after 7 days, my lord, the complaint has been lost, so it can consider it.
Well, whatever may be, he did not disclose it. So therefore, to come to an actual figure, it becomes difficult. Here also it must have been the same thing. Now, if I dismiss that petition holding what you said in that matter to be right, then I will be bound here to ask you to look into this. Don't you think so?
But man, that 7 days period is again an issue, man, in that particular tender.
7 days.
There is a clause that after
7 days is for him. But the fact that he did not disclose. Here also he did not disclose. It is not the question, the bid capacity, for the purpose of getting the bid capacity, your basic understanding, that is why you have a minus B.
Minus B.
The minus B means you have already availed for getting other works on the basis of your available bid capacity, which you have earlier worked. So therefore, we are minusing this portion of the work which you are doing or is going, unless you get the completion certificate. Yes. So that is why it is cancelled.
Your lordship is, but my humble submission, my lord, and humble understanding is that, my lord, page 221, he has stated about the ongoing works, my lord.
Understood. Did you have mentioned about the both the works?
My lord,
Let's see.
technical with page 221, my lord. Additional, in the additional.
This is as per section 3.
My section 3.
There is only one work.
One work, my lord.
You have 2 works.
I have 2 works, my lord, but that work is yet to be started. In my
That's
reply
the-
also, I
that
have.
is the question. The basic reason behind this available bid capacity is whether you have used your capacity
My lord.
in getting another contracts which are presently in function. or you execute. If you have got that benefit, so therefore it has to be subtracted. Kindly come to page 75.
My lord.
You see, how do you do it?
Assess
A
the-
into N. A is the maximum value of
Value of-
engineering works executed during the last 3 years. Okay.
My lord.
Then into
Number.
number of years. Number of years prescribed for completion. Then
Value.
minus it with B, but multiply by 2.
My lord.
And this you arrived at, there is also a particular thing by which it is being given into, you have to up to date it with a particular year. Here it is not given, na?
But that will be in that form.
No, here it
That's
should
the
be here
appendix.
only. No, here it is not there. But anyways, to bring it to a particular level, it is not given here, unlike in that contract. So therefore, without the B being mentioned, there's been rightly, and then it becomes a L1, then becomes only one successful bidder.
My lord.
And one successful bidder in view of section 24 or rule 24, they take out, go for fresh. That's the answer.
But I have approached before your lordship, my lord, because of my lord, they have cancelled the bid, my lord, without any reasoning, my lord.
That's the
Only
reasoning.
they
You
have.
want the reasoning. I can issue a notice, they will give you a reason. But this is the reasoning here they are going to give, isn't it?
Yeah, in fact, when the petitioner has admitted that that is the reason, in para 12. He knows that.
And you also know. You see, unless that, you cannot compute without B. How do you compute without that figure as regards the ongoing? You see B, page 75, B, what is B? Value updated to the price level of the year indicated in the appendix. Meaning thereby, if it is the same year, then into multiply by 1. If it is by 1 year more is so and so. Of the existing commitments, means all commitments.
All committed.
And ongoing works to be completed during the next 24 months.
Period of completion of the works.
Period of completion of the work for which the bid is invited. So therefore, you cannot arrive at unless you mention this.
But so far as their column, my lord, they have mentioned about the anticipated and value of the remaining works and such. When the particular work is uncertain, my lord, since they have issued the proceed to work, that in respect of second work, my lord, I am submitting before your lordship. Here, my lord, they have I have to yet to start, my lord, work.
Isn't it an existing commitment?
My lord,
Are you saying that that is not an existing commitment?
that may be cancelled, my lord. In my reply, I have
How can it
stated
be
uncertain,
cancelled?
my lord.
How can it be cancelled? You have already been issued a notice to proceed with the work.
But in my reply, my lord, I have stated this, my lord. That since, my lord, there is a no drawing, nothing, my lord.
Huh?
That no drawing of the work, my lord. Since the construction of a building, my lord, they need to prior to proceed with the work, they need to issue the drawing of the building, my lord. That was not done. In my reply, my lord, your lordship, clearly I have stated.
No. Then are you saying that have you given up your claim over that contract?
Second contract.
Yes.
That is uncertain, in fact.
No. Have you given up the claim? No.
That is not done.
Then it is an existing commitment. That is why I'm saying. What to do? Withdraw or dismiss? Dismiss?
In fact, my lord, one day, tomorrow morning, I just obtain my instruction from my client. My lord. Tomorrow morning, my lord, at 10:30.
10:30, the other matter is there. Huh? Okay. While I dictate to allow those petitions, I dismiss yours. Same process, same matter. So therefore, I remember. And it will be good also when I'm having it tomorrow. then he will come up with that submission. Because he can't make two submissions. Release the matter tomorrow.
Fifty-three.
Then side visit.
Yes, what is it?
But let the petitioner expose my lord, the office my lord, of the executive engineer, they will issue. But one thing I would like to point out, my lord, this is a photograph at page 25. The contractor is not there. But you will see in all other cases, the contractor is there, my lord, in the photo.
What type of photographs are those?
Whether he has gone or
You
not.
can go also there
Yeah.
and take a photograph.
I received these photographs only, my lord. Contractor.
Contractors should be there, then how will a person know that you visited?
I have 4 photographs, but like same photograph.
Huh?
No one is there.
Yes. So we do one thing. Taking into account that the contractor is not there in the photograph, I give you the liberty to submit.
Yes.
To submit it by tomorrow and get the search, and they will provide to make that application with photograph.
Photo.
Because the last date is on 29, na?
29. Tomorrow is 28th.
I have heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi appears on behalf of the respondents.
Yes, all it.
Respondents. The petitioner herein is aggrieved by the non-issuance of the site visit certificate, which is mandated as per clause 7, na?
Yes.
6F.
Clause 7 of the.
6F.
Yes, 6F.
You have not enclosed
6F.
that also.
6F, my lord. 80. Page number 19, my lord. Page number 19.
Where? Which is mandated, which is required in terms with clause 6F of the detailed notice inviting tender. It is the case of the petitioner that the petitioner had visited the site pertaining to the work, namely improvement and upgradation of Gopur, Kamdewal, Hawazan Road under Ahom Mala 3.0 for the year 2025-26. Mr. B. Gogoi, the learned counsel submits, appearing on behalf of the respondent, submits that the respondent number 3, na?
Yes.
3 has no objection in providing the certificate, provided the photographs contain provided the photographs with geotag containing wherein the petitioner is being shown as the representative of the petitioner. What is this company or what?
Company, construction company. Construction company, my lord.
Representative of the petitioner firm is shown as to be present in the site in question. Ms. So-and-so Kesina N. Gogoi, appearing on behalf of the petitioner, submits that the petitioner would submit due certificate by tomorrow. And tomorrow, along with the photograph, evidencing that the petitioner, the representatives of the petitioner have duly participated, have duly visited the site in question. So taking into account the above, the incident with petition stands disposed of, thereby granting liberty to the petitioner to submit an application before the respondent number 3 along with a photograph containing the geotag location wherein a representative of the petitioner is being shown as to be present in the site, and upon such application being submitted, the respondent number 3 shall forthwith provide the site visit certificate. The above the petition stands disposed.
Obliged.
Item 21.
No, in this case, Kendriya Vidyalaya has submitted affidavit in opposition, but BTC has not submitted their affidavit in opposition.
What? There's an affidavit in opposition filed by somebody.
Kendriya Vidyalaya.
Participant number 3, 4, 5, and 6.
What is the matter about?
No, there is a case, my lord, that in order to set up Kendriya Vidyalaya, in order to set up Kendriya Vidyalaya in Udalguri, my lord, the property was taken from me by the, my lord, the BTC, my lord, under certain terms, my lord. But despite of that, my lord, though the amount was decided by them in respect of the property, that page 19, but
They have taken your land.
yes, my lord. But my lord, the amount has not been paid. Page 19 is the, my lord, letter.
They have filed an affidavit.
Yes, my lord, respondent Kendriya Vidyalaya submitted the affidavit, but BTC the affidavit is necessary.
Lordship, you are aware of the situation with BTC. We will file our affidavit in 2 weeks' time, Lordship.
Okay, you in the meantime file reply if you have anything. The respondent numbers 3 to 6 have duly filed the affidavit in opposition. Gusto. Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to go through the same affidavit and if necessary, file a reply. Mr. So-and-so, who represents the BTC, submits that he requires 2 weeks' time to file the affidavit. Who appears for the DC? Ms. Yudas shall also obtain the necessary instructions to accordingly list this matter on 1st of December 2025. In the meantime, the respondents, other than the respondent number 3 to 6, are given the liberty to bring on record their stand by filing the affidavits on or before 24th of November 2025. Ms. Yudas, the district commissioner, which one? Which district?
Udalguri.
Udalguri is further directed to provide the necessary instructions to Ms. Yudas in respect to the instant matter.
Check, an extra copy of the petition may be furnished to us.
What?
Extra copy of the petition.
And that has been furnished long, but now I think standing council has been changed. Anyway, she will provide.
Provide one copy.
Yes, ma'am, absolutely.
22 and 23.
Your Lordship, I'm appearing on behalf of my learned senior, Mr. K. Bhyal. He's absent due to ill health today. Your Lordship, kindly allow us some time to file the affidavit in reply for both item number 22 and 23.
You have filed the affidavit?
In 22.
Now,
22, we have filed it.
sir, your Lord,
And
my Lord, 23 just received.
23 lots in my senior family. My money is being filed out.
Today?
Yes.
What is his stand? Let us see 22.
Lordship, here the site certificate could not be given because the photo that he gave, Lordship, in all the photos, 3 different persons were here. And 3 different persons' photos were not the petitioner.
Naranjyoti Talukdar.
Yes, Lordship. Kindly allow some time to
No
file.
time. What is this? You are Naranjyoti Talukdar. So why none of it is your photograph?
So this is.
There is a clause wherein you have to visit
Yes, sir.
and ask for the site visit certificate. All the three photographs which you have enclosed at page 27, 28, and 29 of the writ petition are three different persons. Isn't it?
No, Your Lordship, they're the same person.
How can be same persons? All these are three different works?
Yes, Your Lordship.
Yes or no?
Yes, sir.
Then tell me, if all these are three different works and you have therefore enclosed three different photographs, then why at page 27 and 28, the timing of both the photographs are same?
The location construction also same. The tagline of the construction, both are same.
Your Lordship, I'm currently unaware because my learned senior is handling this case.
Your senior is what?
My learned senior is handling this case. I'm just appearing on behalf of him. He's currently absent today.
Okay, let me dismiss one of them. And your affidavit, you are filing it today, na? It is seen that the affidavit has been filed. Noyan Jyoti Talukdar. WPC number 4455/2020. The petitioner heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. So-and-so appears on behalf of the PWD department. The petitioner herein is aggrieved by the non-issuance of the site visit certificate by the respondent number 3. In respect to the works specifically mentioned at serial number 1, 2, and 3 of the NIT dated 9/7/2025. Pursuant to the writ petition being filed, this court had issued notice by an order dated 7/8/2025. An affidavit has been filed by the respondent number 3. wherein it has been categorically mentioned that the petitioner submitted an application dated 28/7/2025 before the respondent number 3 with 3 numbers of site visit certificates for 3 numbers of packages. It was found upon perusal of the said applications, including the geotech photographs. And it was further mentioned that upon perusal of the applications, including the geotech photograph, it did not establish that the petitioner's physical presence at the respective site as required under clause 7.1 of the instruction to bidders. This court have also perused the photographs enclosed to the writ petition at pages 27, 28, and 29. And from the said photographs, it is not discernible that the petitioner was present in the said, had visited the site. Considering the above, this court doesn't find any merit in the writ petition for which the writ petition stands dismissed. Other matter, you were filing the affidavit, huh?
My with Lordship, my copy I have not, I have already furnished.
What is the reason?
But in this case, Lordship, although he submitted one application, along with the application, no photographs have been enclosed.
What?
That is the stand in the affidavit, Lordship.
This one, na? Person, isn't this the person? Page annexure 5.
No, the Lordship here also, the other petitioner, Lordship, he was authorized to visit the site on behalf of the petitioner, Lordship. That Nayan does.
Huh?
Other petitioner Lordship. If Lordship goes to this application at page 28, Lordship here, he has authorized the other petitioner to visit the site on his behalf. Hence, I do hereby authorize Mr. Nayanjiti Talukdar, resident of so-and-so, as my official representative.
How can that be? Does this Nayanjiti Talukdar work under you?
Yes, Lordship. They are actually co-partners, they work together.
But you are not submitting as a joint venture.
Yes, Lordship.
Are you not a registered?
No, he's also a registered contractor, Your Lordship. Munafa Ahmed is also class 1 contractor.
You are a class 1 contractor, Munafa Ahmed.
He's a
Thank you, sir. You are all independent. He is also a class 1 contractor. How can you employ him? He can't be your employee. I would have understood that he is your representative. It's a different thing. But he is also a class 1 contractor.
That is one Lordship. If Lordship comes to page 24. Who should visit the site, Lordship? 6, clause 6, site visit. 7 is important. The visitor is advised to visit the site of work mandatory at his own cost, so and so, so and so. Site visit by the bidder is mandatory.
Where?
But
Site visit by the bidder is mandatory as the site is full of number of existing structures. Hello. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. I've heard of also Mr. P. Naik, the learned additional advocate general, who also appears on behalf who is also the standing counsel of the PWD. The petitioner herein is aggrieved by the non-issuance of the site visit certificate as requested by the petitioner by the communication dated 4/9/2025. Also, this court had issued notice pursuant to the filing of the incident with petition. Mr. P. Nayak, the learned counsel submits that have you filed the affidavit?
I have already furnished copy. Now, it will be filed today in any case.
I have submitted that the affidavit has been filed detailing out the reasons why the petitioner have not been issued the site visit certificate. Be that as it may, the learned petitioner advocate general has drawn the attention of this court to clause 7 of the information and guidelines for the bidders. So taking into account the clause 7 of the said clause 7 being relevant, the same is reproduced here in under page 24. Mr. P. Nayak, the learned counsel submitted, learned additional advocate general submitted that the petitioner admittedly did not visit the site, as would be seen from the very communication dated 4/9/2025, annexure 5 to the writ petition, wherein he submitted, wherein the petitioner had himself stated that he had authorized one Mr. Noyan Jyoti Talukdar to visit the site as his official representative. The learned counsel submitted that there is no material shown that the said Noyan Jyoti Talukdar is a person working, is an employee. Right? Is a representative of the petitioner. Additionally, the learned senior counsel submitted that in fact Sri Noyan Jyoti Talukdar is also a class 1A contractor, as would be seen in WPC number 4455/2025, which is another writ petition tagged along by this court by an order dated 14/10/2025. This court, upon hearing the counsels and having perused clause 7, finds it pertinent to observe that the said clause mandates that a site visit by the bidder is mandatory. More so, as the site is full of number of existing structures. Considering the fact that the petitioner did not visit the site, as it is the self-admission of the petitioner in the communication dated 4/9/2025, this court doesn't find any merit in the instant writ petition, for which the writ petition stands dismissed. You filed the affidavit.
24.
Yes.
May it please your lordship, my lord, on the last occasion, your lordship had passed an order directing for.
Anything happened to the appeal?
No, it has been disposed of. The holiday listing has been revoked.
No, it has been revoked only to the extent of the last remaining 2-3 months, not fully. And secondly, there was another aspect of the termination of the contract, and they have said in the order that that is outside the purview of the appeal. And outside the purview of the appeal, that is not appealable. That is the opinion expressed.
Okay, let me dismiss that part on the ground that there is an arbitration clause. So I dismiss that part.
But Your lordship may see another aspect.
No, I won't say anything.
You'll-
Termination go to arbitration.
No, your lordship had directed participation of the appeal, writ petitioner. And they have said that the kind of order they would be passing, or rather they have passed, participation is not necessary. Second page,
No, accordingly, the order dated so and so in for 1 year is hereby revoked. And so is removed from holiday race with immediate effect.
yes.
What else do you want?
No, my lord, if your lordship kindly sees the previous paragraph, para 4, they have said that considering that over 10 months have already elapsed. So that 10 months, they are not disturbing. Is it not my lord, this is not a removal right from the day of 2nd of January 2025. Had they said so, that it is right from the beginning of 2025, then perhaps the aspect would have been different. Since the order of holiday listing dated so and so, the period of debarment already undergone is viewed as sufficient.
Only thing is the tag.
Tag, yes,
The tag is you are challenging.
yes. The tag.
You file an additional affidavit. Now the interim order doesn't have anything. There's no question of any interim order.
No.
So you file an additional affidavit bringing on record this challenging the tag.
Yes.
And
Another aspect is
termination. Termination, I'll go to arbitration. You're challenging the termination also.
Yes, yes.
On what ground?
Well, they have terminated the contract on the ground that I have exceeded the period granted, the time limit granted. That is the ground, one of the ground. Our contention is that time is not the essence of the contract as it would appear from the circumstances of the case, because they terminated our contract on the ground that we have crossed the time limit. Thereafter, they sat over for the matter for 7 months. And thereafter, the private respondent has been entrusted the work. So for doing the remaining part. So it could not be said that merely because I could not complete it within the time limit granted.
Mr. Dutta, time was the essence of the contract will be looked into after what they does or
No,
what was
my lord, for that matter,
at the time when the work was given?
my lord, for that matter, the terms and conditions.
Deal with section 55 of
My
the
lord,
Contract Act in a writ proceedings. Time was the essence of the
My
contract.
lord, for that matter, terms and conditions of the contract are essential, my lord, I admit that. But the kind of conduct that they have undertaken.
Conduct, no conduct. Those conduct are for section 11 as well as for those arbitration. Nothing to do with it.
Well, we prayed for only 2 months, my lord. We prayed for only 2 months, they did not grant it.
Yeah, whether for that any loss has occasion to you, you may be entitled to damage. It has already been given to the respondent number 6 or 7.
Yes, but at the same time.
Now you want that work be done by you.
No, my lord, at the same time, they have withheld my money.
Mr. Dutta, tell me, now you want to do the work?
No, I expressed my willingness to do the work. I expressed my willingness to do the work.
Now you want to do the work?
No, even at the time of cancellation, my lord.
Now, can you do the work?
Perhaps it has considerably progressed by now.
Then you cannot do the work now.
Yes.
So the only thing is damages.
Damages.
And as regards an illegal termination,
And
which I can't give you.
well, I can understand. I can
Unless I am
understand
sitting as
that.
an arbitrator.
Well, I can understand that, but your lordship will kindly
The
consider.
judges don't take up arbitration.
My lord, your lordship may also consider another aspect of the matter. On the ground of allowing the private respondent to do the work, they have withheld my admitted bill.
Obviously, because
They-
it is being done at your risk and cost.
My lord, that is the subject matter of challenge because the terms and
That
conditions.
subject matter of challenge cannot be put here.
No, my lord,
Go there. It's
My-
the question of arbitration.
my lord, the terms and conditions of the contract
I
say.
refer also not only to arbitration, I also refer to section 11. Go there. Do whatever you.
My lord, in the terms and conditions, they say risk and cost will come only in the event when I do not mobilize the, machineries and plants and machineries. There was no clause in the contract that for delayed completion, my lord, there is a provision for granting liquidated damage. That is there.
But now, are you saying the NRL does not have a condition that if you don't do the work within time, they can get the work done through a third party?
No, I am not saying that.
at
They
the
can do
risk and
it.
cost?
No, in the terms and conditions of the contract.
No,
my
no,
lord.
I'm therefore saying, in
Yes.
the terms and condition, there is no clause?
No,
It
there
is
is
not
only
possible?
clause, my lord, subject to correction by my
Okay,
friend.
if we get it, then we dismiss your petition right away. Take it.
Well,
Then for the division bench to look out. Where are the terms and conditions of the contract?
page 84, your lordship, I can
Where
listen.
are the terms and conditions of the contract?
GCC has not been annexed.
Not enclosed.
No, not the GCC, my lord. This is the terms and conditions on which, my lord, the
That
contract
will
began.
amount to suppression. We dismiss on that now. Suppression of which.
No, my lord, in that,
We have not enclosed the terms and
no,
conditions.
terms and condition is there, my lord.
Where?
Page 84, your lordship, I can listen. It starts from 48. It starts from 68, but the aspect of,
Are you saying that the terms and conditions are only the work order terms and conditions and there is no tender? Or
No,
have you been
no.
given without a tender?
no, there are terms and conditions.
Then,
But in that,
on that basis.
my lord, in that GCC, my lord,
I think it would be, Mr. Dekai, wouldn't it be clause number 2 or 3? By which it is being
Earlier
done?
it was 110, now.
There?
my lord, I am not saying
In
that,
fact, page 49 refers specifically
No.
to 60 months.
no.
The petitioner has disentitled himself to get the benefit of 6.
No, my lord,
Not enclosing all these documents, not disentitled themselves.
no, my lord, I can, in the additional affidavit,
Dismiss on that
I,
ground.
no, my lord,
Disentitled.
I have it with me and there is an amendment made in the petition that at the time of hearing it will be produced because it is
It is something like Mr. Dotto hearing it. I was thinking of doing that.
No.
I was thinking of completing it.
No, my lord, it is
that complete.
that statement is already made in the petition.
No,
It is-
that has no value unless and until those terms and conditions. You are asking about the risk and cost, but the risk and cost factor is always there in the term and condition of the contract,
No,
wherein it says, and I would be surprised if that terms and condition does not contain that if a person does not complete the work, the employer does not have the power to get it done through a third party at the risk and cost.
No, it
This
is there.
Normally, as if it is the general terms and conditions
My
of
lord,
the contract.
my lord, they have fashioned it in this manner. If I do not complete it within the time, they can get it done by a third party and a liquidated damage can also be imposed on me.
That is,
But
liquidated damages is better. Liquidated damage is different, but here is a case that they have quantified it.
No, they have, I mean,
They have now done it as per 74. Isn't that, Mr. Deka?
Yes.
Yeah?
well, they have phrased the wordings in this manner, my lord.
Case.
In any case, if your lordship is granting me to file an additional affidavit on that point of the holiday listing, my lord, the GCC is right with me, my lord. I can also enclose it with the additional affidavit. Your lordship can see that.
Your liberty.
Your
I
lordship
am
can.
not giving those liberty to do whatever you will. But as regard this, I can give you a liberty.
Well, that will be
This
enough.
particular thing, because you may have to challenge this little bit of things.
Yes.
They are saying that the entire is bad. Or you may have to file a separate petition for this particular purpose, taking into account they held this 10 months was good.
Yes.
You may have to challenge this.
Yes.
Or but by additional affidavit, can you challenge that? Oh yes, it may be a continuation. I may be of a view of this tomorrow. The next coordinate bench may not be. So you take your chance.
Technically, my lord, perhaps the writ petition deserves to be amended. Technically.
Or
But-
a fresh writ
Or
petition.
a fresh writ petition.
Technique.
But otherwise, my lord, by bringing
Depends on
an
which technical judge is sitting.
but otherwise, my lord, by bringing it on additional affidavit, my lord, that should suffice.
Yes.
That should
And
suffice.
thereby giving him an opportunity.
Yes.
You have filed your affidavit, no?
No, man, we have not filed that.
Okay, you'll file it.
We'll file.
Let him file a reply, additional. You are filing an additional affidavit, no?
yes.
Okay. Then thereupon you
We'll
file.
file, we'll file consular.
Mr. S. Dr. Dalal, senior counsel, appearing on behalf of the petitioner, submitted that in pursuance to, submitted that in the meantime, the appellate authority have already decided the appeal as regards the blacklisting of the petitioner. And passed an order on 24/10/2025, whereby though the blacklisting order null has been revoked with immediate effect, but had approved the blacklisting which was done till 24/10/2025. He therefore submits that he would like to file additional pleadings, thereby also challenging the communication dated 24/10/2025 in the present proceedings. Leave granted to file additional pleadings. How much? 2 months, 3
No, no.
months?
By next week.
Okay. This is the matter again on 7th of November.
Well, only thing is that your lordship has perhaps said blacklisting, that will be holiday listing.
Holiday.
May please, your lordship.
What is this? PRC?
Yes.
But it is also the case of the petitioner that the registration of the PRC cannot bar the settlement to be made in favor of the intern. Oh, yes, that matter. Yes,
Yes,
what
ma'am.
is your stand? The PNRD department is a bit slow, I know. And I issued the notice very early. Huh?
No, 1 week time again.
So I've stopped, I passed an interim order.
But settlement period is only for 1 year, my lord, and 4 months already gone. Date may be fixed on the next week, my lord.
You are the highest bidder.
I am the highest bidder, highest valid bidder, and my name was recommended by the my lord.
No, only on the ground that you have been, you have a
case.
case against you.
Yes.
That is the reason
Yes,
why.
only
Na?
one.
So you say that this clause 19 would not apply,
Yes,
isn't that?
yes.
Yes, yes. And PNR say you don't want to file affidavit.
Instructions.
Next week. Miss Enbora, and if instructions are not given to us, we will understand that these PNRD officials do not require the assistance of lawyers, and we'll ask them to appear in court. This is not disrespecting us, but this is disrespecting the laws. I hope you make it clear to them. Yes. Ms. Enbora submits that the instructions are awaited. So she therefore submits that as there is an interim order to the matter will be listed next week so that the material, the instructions can be produced before this court. Taking into account the above, list the matter on 7th of November 2025. In the meantime, the PNRD department shall place before this court its instructions by way of an affidavit.
Interim order may be considered.
Interim order passed earlier shall continue till then.
Obligation.
Supplementary item 54.
Yes, who is appearing for the government?
But in this case, we have received the paralyzed comment lots in 1 week time. We got to file the application.
Read this IA.
That is for the interim orders.
I passed an interim order,
Please, Your
so
Lord.
it's okay.
That was, in
Okay,
paragraph
you
six.
do one thing, you file your affidavit. When are you filing it? Are you sure?
Yes, Lord.
Positive? Fantastic. So you file your affidavit by 7? Give them the liberty to file their reply by 17? And then we keep the matter for consideration on 20, as there is an interim order.
Keep your pen.
Ms. RDB, the learned counsel appearing on behalf of the respondents, submits that the instructions have been already provided to her, and the affidavit can be filed by 7th of November 2025. Pusto. This court also takes note of that there is an interim order passed by this court. Considering the above, this court fixes directs the grants liberty to the petitioner to file reply on or before 17th of November 2025. To list the matter on 20/11/2025 for consideration. For consideration, and on which date an attempt shall be made to dispose of the petition. Pusto. Interim order passed earlier shall continue till the next date.
Keep your pen.
That's item 26.
Yes, madam.
Item 26.
Is there a stay? There's a stay order.
That is status quo. Status quo order. Work order has already issued. Work order has already issued. They have challenged your work order.
Why no name of payer is not shown? So it is seen from the cause list that the name of the petitioner, counsel for the petitioner have not been shown. So considering the above, is this matter? On 3rd of November 2025, showing the indicating the name of the counsel appearing on behalf of the petitioner. Else we have to dismiss it. No?
27.
May please, Your Lordship. As per last order, Lordship, the respondent will provide the schedule as how and when the payment of the bill will be made, Lordship.
Yes, what is the schedule?
My lord, we'll file my affidavit, my lord. Before that, my lord, what has happened, there are some positive development, my lord. Total amount on that particular day was 11 crore 41,851,000 odd rupees. In the meantime, my lord, 10% have been paid on 25/11/2025. And thereafter, my lord, on 21st of September, 6 crore has been released. 6 crore. Total he has received till date, my lord, 7 crore 14,18,171 rupees. And 4 crore 27 lakhs and odd rupees is left, my lord. The principal secretary, because there was an election there, my lord, thereafter, my lord, principal secretary now sent to Bihar for election duty. He's out of station, my lord. Will return on 14th after the counting, my lord. But we will post it after 14 months. In the meantime, he has assured that payment will be released.
Mr. Ergora appearing on behalf of the respondent submits that more than 50% of the amount have already been.
Almost 70%.
More than 50% will include. More than 50% of the amount as directed have already been paid to the petitioner. And the schedule as sought for by this court by the order dated 11/9/2025 could not be produced before this court, taking into account that principal, that the alleged contemner, that the respondent herein has been sent on election duty to Bihar on account of the legislative assembly elections. He submits therefore that the matter be taken up after 14th of November 2025. To list this matter on 21st of November 2025 for the approval.
28.
Yes,
Lordship will withdraw the case. There is a possibility to getting the payment.
what? You cannot withdraw contempt. Contempt is not permissible for withdrawal. That- You cannot withdraw. Withdraw contempt, one notice issued means it has to be brought to a logical conclusion. Because once you bring it to the notice of me, it is between me and her. Isn't it, madam? Then
Lordship, matters may fix after 14th, Lordship, because principal secretary is in
Huh?
election duty. Matter may fix after 14th of November.
Bihar elections. Same principal secretary.
30, 20.
You are paying for respondent number 3,
Yes, Lordship. Akash.
Akashdeep.
Yeah.
Ms. Avi Bora, appearing on behalf of the respondent number 3, submits that the alleged contemner has been he is presently sent for election duty to Bihar on account of the Bihar Legislative Assembly elections. She therefore submits that matter be posted after 14th of November so that the petitioner and the alleged contemner would be in a position to file the response. List this matter on 28th of November 2025. In the meantime, the response be brought on record.
Lordship, after 14 November, he will come.
I'm fixing it on 28th November,
Lordship.
giving you
Right.
14 days thereafter.
29, also similar prayer.
Same order,
Same, Lordship.
29,
30 and 31.
Yes, Lordship.
30 and 31 also.
30 and 31, application for inclusion not received. Wait,
31 is,
30.
31 is mine.
no, 30,
30 is there.
30, I'm.
30 conditions. 29 is same, na?
Yes, Lordship.
Okay, give me 30. Same order.
30.
30.
30, no respondents, then so. Advocate, Akash, Anurag, well, and.
Wait for 2 weeks time is granted to our to file application in the new incumbent. It is seen that this court passed an order dated 17/5/2024 to file application, thereby granting liberty to file application for impleasment of the new incumbents in the post of the Principal Secretary, Boroland Territorial Council, as well as the Secretary, Irrigation, Boroland Territorial Council as parties to the respondents. No steps have been taken in that regard. Considering the above, it therefore appears that the petitioner is not. Are you going to take steps or not?
Yes, yes, Lordship.
Counsel appearing on behalf of the petitioner submits that steps would be taken. So considering the matter, the instant contempt application be listed only after the application for impleasment is filed. It is observed further that in the circumstance that such application is not filed within a period of 6 months from today, the matter be placed before this court for appropriate orders.
31.
31 last,
31,
the last occasion, matlab, they took 2 weeks time matlab, to obtain instruction.
same order, na? It took 2. 31, you are 2.
32 is.
Yeah, for respondent number 2, yes.
31. Yes, two.
Three now.
Akash.
32.
31 is any day.
Same.
Same Lordship.
31.
33.
May I please, your lordship? Lordship, in this case, Dusty by way of, notice by way of Dusty service has been taken, lordship. And an affidavit has already been filed, lordship, placed at flag B, lordship. An amended cost title has also been filed, lordship.
Oh, yes, this is important. You have taken steps by Dusty?
Yes, an affidavit has also been filed, lordship.
By?
Lordship?
Who has filed? You have filed?
Yes, that is marked as flag B. Upon the newly implemented respond number 4, lordship.
Okay, the chief secretary has not responded.
Lordship, in the meantime.
We have also given Mr. B. Gogoi he has also not come, so we asked the chief secretary to be present to give him.
Vishram.
Yes, madam. Madam, it has been covered. I thought, madam, amount has been requested.
Lordship, that is disputed, lordship. The amount that is accrued is 11,62,538 as on 7/3/2024, lordship. And the amount that has been received by the petitioner is 11,51,000, lordship.
Obviously.
Lordship,
There
that
will be
interest,
deduction.
that interest of last 1 year, lordship,
That is okay, but this is up to
7/3/2024, lordship. And we are on in October 2025.
Huh?
That was on admission of PWD as on 7/3/2020.
1162, you have got it.
1151.
Why 51 you have got?
Madam, there may be some deduction, madam.
How can there be a deduction on,
Yes, madam.
because recently the Supreme Court also said that there cannot be a deduction on land acquisition. How is it possible?
That I will have to see inspection, why, but because the
Anyways,
all letters say, madam,
1151 has been paid.
15.
This is up to
7/3/2024, lordship.
7/3/2024. What about the others?
Rest, my lord, that was the proposal, my lord.
No, they're not only the
Of course,
proposal.
It is accruing, my lord.
And what is the stand of the commissioner and secretary finance? So how are you going to, because it is a mistake committed by these officials.
Not,
Are you going to, because this I'm taking it seriously on the ground, that are you going to take it, this additional interest from the salary of these people? You have to do that, because then only they realize. They
That-
cannot. It is something very serious they have done.
That was observed by the last order also at paragraph number 6 by your lordship's order. Paragraph 6.
It is because of this order you got the money.
last,
Lordship.
immediately it was sanctioned as my lord amount release. When I applied for it, yeah. Almost it was again, I think it was-
But you file an affidavit as regards paragraph 5(6).
Lordship.
The commissioner and secretary has filed an affidavit. As to what action? Because you see, you can't keep this matter pending like this.
Yes.
After all, it is the state's public exchequer, you have to pay. There's no quarrel with that. You can't challenge that aspect. And why the delay has happened? And the moment it is delayed, it is statutory
Yes.
interest. They should know.
Yeah.
Unless you take some action against these erring officials, I should not drop this. Because if you take some action, then I think these erring officials will learn. Because interest, because you said 1 lakh additional means you are taking this 1 lakh and depriving a person who is otherwise entitled, not him. But this 1 lakh which you paid him as interest is an amount which could have been spent for the benefit of some scheme, isn't it? And it is because of the laxity on the part of these officials this has happened. They knew that the interest had to be paid. Matter has attained finality so far back is in the division bench order.
Division bench order.
Division bench order.
There.
October.
Okay, it has been brought to the attention of this court that by the ordered, the tension of this court that pursuant to the order passed by this court on 24/9/2025, the petitioner have been disbursed an amount of rupees 11 lakhs,
51,000 Lordship.
51,000,
51,000.
51,000. The learned counsel appearing on behalf of the petitioner submitted that as on 7/3/2024, the amount was rupees 11,62,538. However, the petitioner have only been paid an amount of rupees 11,51,000. He further submitted that the petitioner is further entitled to interest at the rate of 15% with effect from 8/3/2024 till date. This court inquired with Mr. B. Gogoi, the learned counsel appearing on behalf of learned additional advocate general, as to how the payment of 11,51,000 have been paid, and to provide details before this court. Mr. Gogoi, you see, the thing remains like this. 3,03,180 is the amount, principal. Interest is accrued at 9 and 15%. Okay. Now, the moment you are paying, the interest as on 7/3 is 11,62,000, or you are paying 11,51,000, just for example. You have to deduct from what is accrued as on today.
Yes.
And then the remaining will continue to remain as a principal. See the Gurpreet Singh's argument. So on that small amount, there will be an interest. It will be way less, but I think 11,62,000, 3,03,180. Therein only 15% interest will be given.
Yes.
So there cannot be any interest on interest. So 3 lakhs had become 11,62,000.
1 year.
But while taking apportioning, you first deduct 11,51,000 as on date, what is the amount? And then thereupon, I think it will be on 25,000 or 30,000, there will be an interest of 15%. So you look into that aspect. And this could further would require the stand of the newly implemented respondent number 4 in respect to the queries made at paragraph number 4, 5, and 6 of the order dated 24/9/2025. List the matter again on 10th of November 2025. It won't be much, but
Yes.
I think you need to pay and finish it off. Otherwise, they will be keeping on accruing. And file an affidavit as to how it will be taken. No affidavit.
No affidavit.
Lordship, affidavit has been filed, your lordship, and we stated that we have already forwarded the monitoring status report to the Brahmaputra board, your lordship. But because of non-release of fund from Jal Shakti, we could not release, and we have already filed review in this particular application, your lordship. And
You have been dismissed.
review dismissed, but there is one observation that is they have not made party to the concern.
And it is absolutely for him.
Yes, your lordship. That is our contention, your lordship.
So he has only made these people a party.
Yes, not made Brahmaputra board.
Should have made those people a party.
Party response.
Okay, your affidavit you have filed.
Yes, your
So
lordship.
we bring on record that affidavit
Yes, your lordship.
and then we close it. See the judgment of the Chief Justice Gawai and Justice Mash, on this aspect that certain payment cannot be made on account of beyond your control, that would not amount to contempt. Find it out, there's a judgment out. Then we close. Miss Hardeka, appearing on behalf of the respondent, submits that an affidavit has been filed. The said affidavit, however, is not on record. Lists this matter on 10th of November, along with the said affidavit. You look into that.
35 same,
Same.
35 and 36 same.
No, 34 and 30.
35.
34 and 35. So what is 36?
My lord, kindly, it is 18-8 order, your lordship order.
36.
Eighteen-8 25 order, your lordship.
Engoras, appearing on behalf of the respondents, 4 weeks time for the purpose of filing a detailed affidavit on the basis of a revised report. List this matter on 8th of December 2025.
My lord, may I pray for a shorter time, my lord. 2023 order was there, my lord, for payment, my lord. 23 order was there, my lord.
2023.
23 order, my lord,
Okay.
for payment. And my lord, in the last order, my lord, 18-8, my lord, the council.
Understood, Mr. You have to understand also. Here you have the involvement of the Minister of Rural Development. Things have to be meted out. They are doing some steps. So that is why I'm saying, giving them 4 weeks time.
My lord, letter was of July, my lord, that was sent, my July.
Understood. You get the things done. Yes, today I'll let me do this. All what is the problem here?
Initially, the response number 2 had challenged the notification whereby all the education institutions are brought into the preview of the ESI Act, my lord. And the coordinate bench of this honorable court, under which your lordship will find it. Starts from page 68, my lord.
Now, what is my order?
My lord, your lordship order at the page starts from page 81, my lord. I mean, the operative portion starts from page 83, paragraph 4.
Yes.
Not here, my
So
lord.
you seek a review that it shall be applicable
After retrospectively.
Justice Rishikesh Roy's order.
My lord.
After Justice Rishikesh Roy's order.
My lord, from 2016, my lord.
Because then the interim was vacated.
My lord.
But was there any interim order in the?
Well, there was interim order, my lord, which your lordship will find at page 43. The operative portion, my lord, at page 44. The third paragraph, my lord.
considering the submissions so made on a consideration of provision of the Employees State Insurance Act, the order dated 19/8/2011 is stayed until further orders. My lord, if your lordship may come to the order of the 19/8/2011, my lord, which is at page 42, my lord. It is only for a specific period, my lord. This is the order, my lord, which was stayed. If your lordship may come to para 4 of this, my lord. For the above reasons, I so and so, in excess of the powers delegated to me by the ESI Corporation, I feel and accordingly order that the contribution totaling to about so and so for a period from 1 January 2009 to 3 2010, my lord. That is only for that period, my lord. It was not up to 2016 or 2015, my lord. That order was stayed. Perhaps we are not going to take any action on this basis of this order. Only we are seeking liberty so that the excess contribution may be applied from 2016, my lord. After
The
the
date of that.
date. And my lord, if I may, my lord, place one more case of this honorable court by the division bench, my lord, where a similar liberty was given, my lord. Read April 19 of 22. If the lawsuit may come to page, there are 5, my lord, the operative portion, my lord. There are 5 of this. The submission made by the learned counsel for the respondent is accepted by the learned counsel for appellant in view of the consultation made by the learned counsel for the respondents and an acceptance of the learned counsel of the appellant. This writ appeal is accordingly disposed of by directing that no recovery under the SIC Act shall be made retrospectively with effect from.
Now, you therefore say
My lord.
that in view of Justice Rishikesh Roy's order,
My lord.
to the impugned notification is found to have been in order and accordingly. However, since the operation of the impugned notification was stayed by this,
My lord.
it should be applied prospectively to the INMA. So it will be applied from that date.
No, no. But that notification that in the Justice
It could
Rishikesh
not
order.
have been applied from, because there was no interim order passed in the instant case with respect to that notification.
My lord, that is the different notification, my lord.
But that is an order,
My lord,
which is only for that period.
my lord.
Where is that order? Page 50?
Well, 42 of my review petition, my lord.
So here the order is only 19/8/2011. It's
My
stayed.
lord, my lord.
So this order, it shall be only applicable with effect from the date of the judgment.
My lord, this, based on this.
Date of the judgment, that is 28/1/2016.
my lord.
That's your case.
Yes, my lord. We are not seeking any.
Can't help it. Division bench also say. And in fact, that is wrong. Because there was no stay to the provisions or stay to the notification dated 6/1/2009 in your case. Yeah. Here the stay was only in respect to
The
19/8/2011. So they are not going to take any action on 19/8, but they will proceed prospectively because the stay is to vacate it with effect from 28/1/2016.
Look, my argument will be only that, look, in my case, the 2011 notification was stayed, basing on the fact that the other notifications were stayed in the other petitions.
Understood.
Yes,
But then
Now-
also, that is why I'm giving you the benefit for that.
Yes, my lord.
You are getting the benefit of 19/8/2011. They are not going to take any action on the
Yes.
basis thereof. But you have to submit yourself because there was no stay on the 6/1/2009 notification with effect from 28/1/2016.
Because that was under the operation of stay in some other petitions.
Because otherwise it will be amounting to that you got the matter delayed out here. Would amount to, it is because of this court, you are taking the benefit.
Well,
Cannot happen.
Well, my submission will be, well, they also did not approach this honorable court for vacation of this order or modification of the order after the judgment. They were at the liberty, they had the liberty.
They had the liberty, it is
But they
also
did
isn't it also the responsibility of the court? Chalo. We allow your review. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, review petitioner. and Mr. Gustami, who appears on behalf of the respondents.
Respondent number one, my lord.
Respondent number. The instant review application has been filed, challenging the order, seeking review of the order dated 21/6/2023, passed in WPC number 5494/2011. On the ground that an error apparent on the face of the record had crept in. When this court, by the order dated 21/6/2023, held that the impugned notification dated 6/1/2009 would apply prospectively to the petitioner school from the date of the said order dated 21/6/2023. The learned counsel appearing on behalf of the review petitioner further elaborating submitted that in the present writ petition, in the writ petition, the petitioner had challenged the notification dated 6/1/2009 as well as the order dated 19/8/2011 passed by the Assistant Director of Regional Office of the Employees State Insurance Corporation. The learned counsel submitted by an order dated 2/11/2011. Only the order dated 19/8/2011 was stayed. And not the notification dated 6/1/2009. The learned counsel submitted that the benefit given by the order dated 28/1/2016 submitted that only that the notification dated 6/1/2009 was held to be good by the order dated 28/1/2016 in similar repetitions by the learned coordinate bench, and further observed by the learned coordinate bench that the said notification dated 6/1/2009 would apply with effect from 28/1/2016. The learned counsel therefore submitted that in the instant case, the respondent number one school, in respect to the respondent number one school, the notification dated 6/1/2009 has to be held, ought to have been held as would have been applicable with effect from 28/1/2016 and not from 23 and not from 21/6/2023. I've also heard Mr. D. Gustami, the learned counsel for the review petitioner further submitted that the learned division bench has also clarified the said issue aspect by an order dated 5/10/2023 in writ appeal number 19/2022, holding inter alia that a notification dated 16/1 notification dated 6/1/2009, 6/1/2009 would apply with effect from 28/1/2016. I've also heard Mr. D. Gustami, the learned counsel appearing on behalf of the respondent number one, who submitted that in view of the stay order being granted, interim order being granted, that respondent number 1 herein, the notification dated 6/1/2009 was not applied to the respondent number 1 till the order being passed by this court on 21/6/2023. And as such, the same has to be. And as such, the notification dated 6/1/2009 have been rightly held to be applicable with effect from 21/6/2023 and not 28/1/2016. He therefore submits that no ground for review had crept in for exercising the review jurisdiction. This court, having heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the materials on record. From the materials on record, it is seen that respondent number 1 as a writ petitioner was issued a notice, an order dated 19/8/2011 by the Assistant Director, Employees State Insurance Corporation. The petitioner, therefore, the respondent number 1 thereupon as writ petitioner challenged the said order dated 19/8/2011 as well as the notification dated 6/1/2009 as well as the legality and validity of the notification dated 6/1/2009 by filing a writ petition being WPC number 5494/2011. This court had further perused the order dated 2/11/2011 passed by the learned court net bench, wherein the notification dated 6/1/2009 was not sent. Only the order dated 19/8/2011 was stayed. The record further reveals that by an order dated 28/1/2016, the learned court net bench had upheld the notification dated 6/1/2009 and held that the said notification would be applicable with effect from 28/1/2016. Under such circumstances, it is the opinion of this court that this court, being a coordinate bench, could not have held that the petitioner, that the notification dated 6/1/2009 would apply insofar as the petitioner is insofar as the respondent number 1 herein in question with effect from 21/6/2023. Inasmuch as doing so would amount to this court violating the mandate of Article 14 of the Constitution. Consequently, it is therefore the opinion of this court that there was an error apparent on the face of the record in passing the order dated 21/6/2023 in WPC number 5494/2011. And accordingly, this court therefore reviews the said order, holding inter alia that the notification dated 6/1/2009 shall be applicable insofar as the respondent number 1 herein in question with effect from 28/1/2016. The consequential effect of the above observation is that the order dated 19/8/2011, which was put to challenge by the petitioner, by the respondent number 1 in WPC number 5494/2011 is rendered non-est and cannot be acted upon. With the above observations and directions, the instant review petition stands allowed.
Meet your lordship.
No affidavit received. Who has not filed affidavit? Mr. You are PhD.
Yes, ma'am, yes.
One matter I've asked the commissioner and secretary to be present. Should I ask the commissioner or chief engineer? Because this is something very serious which has happened. And I have nothing against the commissioner and secretary. But the only thing why I'm saying is there's a requirement of control. Because I think the chief engineer may not have the control. The control will be with the commissioner and secretary. Because they are issuing right, left and centers, no completion certificate in 2021-22 without dates and all, and on the basis of which application. If there is no instructions issued by the commissioner and secretary in this time, then you may be in trouble later on. So therefore, I've asked him to be present. Although I'll put your name, you are present in that order. But I think the presence of the commissioner and secretary on 17th, then only he can take action against these people.
I'll inform the committee.
You inform him on 17th, at 17th, I fixed it on 17th, on 10, either of it.
11.
No, I mean 10th or 17th, either of it, I fixed one of the date. So you just inform him only on that aspect, that something has to be done. Some notification has to be issued. Because every time I'm filing, PWD also doing the same thing. But if I correct it here, better sense may prevail with the PWD. Okay, why? What has happened? No affidavit filing.
We had filed it.
Is that also the claim of the petitioner on verification, the admitted amount is 18? How much?
About 18.
Lordship, in this matter, we had made a claim amounting to rupees 23,58,768 rupees.
Now, where is your affidavit?
Affidavit might not be, there must be some defect, madam. We had filed it. And 1 week will be given, madam. I'll correct the defect.
Okay, Mr. Aibot Thakur submits that the affidavit has been already filed, but however, the same is not on record. The registry shall list the matter on 12th of November 2025. In the meantime, along with the said affidavit. If there is any defect in the said affidavit, the same be cured by the standing council of the PhD.
Lordship, we have received one affidavit filed by the respondent number 4. In this affidavit, they had admitted that
The council matter is over.
Lordship.
Okay? And for admission, this is the matter. No affidavit received. Affidavit filed?
Idea file mine.
Affidavit filed?
Yeah.
What is your stand?
As per total figures.
And why they are mentioning no affidavit filed, that there is no affidavit filed? When did you file?
On 18/9.
Yes, madam. 9/9.
Sorry for
Oh, sorry, correct.
9 not.
मेरे से कुछ कर रही तो तुमने लिखा था मुझे तो समझ but the one day I like to do page 30 my lord page जो RDF proceedings my lord.
You have filed the affidavit?
Yes, ma'am.
It has been submitted by Miss Yuda, the learned additional senior government advocate, that the affidavit has been filed on 18/9/2025.
3, madam. That in that case, lordship may be recorded as advocate, madam. For 3, madam.
Respondent number 3.
On behalf of the respondent number 3.
That is.
First of list this matter for admission on 12th of this November 2025, along with the said affidavit, liberty given to the petitioner to file reply if you advised.
Obliged.
40. Lordship, regarding issuance of stamp vendor license, my lord. In this stamp vendor license, my lord. In this case, my lord,
Stamp vendor license.
Oh, stamp vendor, what has happened?
now, my lord, he has filed his application in the year, my lord, 2022-23, my lord.
Yeah?
Thereafter, my lord, all necessary inquiry requirement has performed, my lord, and he was found.
The affidavit filed.
Affidavit filed by the
Sub-register,
sub-register, my lord.
empty date that when to report the office of the does not have the secretary to issue stamp vendor. However, in response to the communication from the deponent provided observations based on the applicant stated demand, it was noted the application may merit considered subject to the direct discretion of the demand and so. Okay, why have you not considered?
Comment number 5 is the kind of competent authority lordship will find page 14 annexed B. My lord, their lordship will find that the Deputy Secretary to the Government of Assam Revenue and Game Registration Department wrote to the area manager Stock Holding Corporation, my lord, that matter related in inviting reference to the subject cited and the enclosure has copy of the letter received from Additional Deputy Commissioner Kachar Shishor to
No. Who issues the license?
Stock Holding Corporation.
License is issued by the deputy commissioner.
Deputy Commissioner.
The vendor license who issues?
What is last lecture B, my lord.
Election?
D of the petition, my lord.
Deputy Secretary to Area Manager, matter of Eastham regarding inviting reference and direct enclosure here with a copy of the letter issued by the demand and to request you to kindly take necessary from your end. So, no, that I'm not concerned, but who issues the license? Huh?
We have
Sorry,
not
State
received
of
the-
Affairs.
We have not received the instruction, my lord, though we have wrote on 17/9/25, my lord. May I pray for some more time, my lord, so that.
The affidavit, this court have duly taken note of. Now, I passed, Mr. M. Setia said that he is filing the affidavit of the respondent number 3
We have not received.
by 22/10/2025. So the respondent number 3 is the deputy commissioner.
My lord.
And he has not given any value
My lord,
to such undertaking. So therefore, we seek his personal presence and see he doesn't give any value to the advocates.
my-
Very sad.
It's correct, my lord.
So
also
we
find
asked,
that, my lord, difficult to get instruction in that.
ah,
Anyway, my lord.
now one or two, I think tweaking here done, then the officials becomes better.
Sometimes-
Otherwise, means madam, I'm not concerned about the court, I'm more concerned about you. Because what has happened, otherwise the government advocates are not given importance.
Correct, my lord. It's correct, my lord.
Yeah.
Sometimes we also feel that treatment should be given sometimes.
They are
but
now being given such treatment,
Correct.
then they become more,
So find difficulty, my lord, requesting again and again. But I pray, my lord, one time or sometime to get instruction. If I don't.
okay, let me pass an order which may help you in getting that.
My lord.
It is seen that that on the earlier occasion, when a matter was listed on 8/9/2025, time was sought for by the government advocate to file the affidavit in opposition on behalf of the respondent number 3. This court granted time to file the affidavit in opposition by 22/10/2025. Ms. Yudas, the learned additional senior government advocate, submits that the affidavit could not be filed on account of want of instructions. It appears, therefore, that the respondent number 3 have not utilized the benefit of the government councils for the purpose of placing the necessary materials before this court. It appears further that the District Commissioner Kachar accordingly, this court fixes this matter on 17th of November 2025 for admission. In the meantime, the respondent number 3 is given the liberty to file the affidavit on or before 14th of November 2025. It is observed that if the affidavit is not filed, the District Commissioner Kachar shall be present through the video conferencing link to be provided by Ms. Yudas, the learned additional senior government advocate, to explain as to what steps have been taken towards the consideration of the petitioner's application for STEM vendor. I think this order,
In your lordship's order that we wrote the letter on 17/9.
it's okay. I think that is enough.
Already, my lord, 40 days has gone, my lord.
It's okay. I think this order is enough.
You are.
Let him be present.
Yes, my lord, we find very.
You just send this order.
Yes.
Oh, yes, what is this? Steps have been taken.
Steps taken, my lord. No,
We need to cancel the entire selection procedure, madam. There are certain procedures.
What are these matters?
My lord, the issue at hand is, my lord, the petitioner, my lord, had applied for a COCO. COCO is a company-owned, company-operated retail outlet, my lord. And these are basically retail outlets which are earmarked 8%. There is a 8% quota as prescribed by the Ministry of Petroleum and Natural Gas for ex-servicemen, armed forces service personnel, my lord. Now, the petitioner had duly applied, my lords. His application was rejected.
Why?
My lords, the entire selection is, my lords, governed by certain conditions which are prescribed by the oil marketing companies, my lord. These instructions, set of instructions are known as the brochure.
Cancellation of the selection process for service provider for so and so, you requested to bring it to the notice of the court before during the hearing today. After intimating in a court as per your advice, we shall inform the applicant that selection process has been cancelled. Also, the extension provided to current service provider is going to expire by this end. This soon after cancelling. So you are
I'm for warrant 2, madam.
submitted that the pursuant thereto the petitioner was awaiting the respondent shall again return the recommendation of the petitioner to the respondent number stated to be sent to the DBR. However, nothing has been done and the petitioner now have come to learn that there is some other person there depriving the right of the petitioner to be considered on the phone. Now they are cancelling.
They're cancelling. No,
They are going for a fresh one.
Yes, ma'am. The cancelling perhaps only will not do because, my lord, the brochure, which basically sets out the procedure involved and how the nominations are acquired, because their selection is only earmarked.
They shall do as per the brochure.
Yes, but the brochure has not been amended, my lords. That is the discrepancy, my
Are you challenging the brochure?
my lords.
No.
You are not challenging the brochure. How can I help you? Read in the mandamus more particular to forward the petitioner's nomination.
Yes.
That is what you are asking.
Yes.
And then whereby petitioner's application for selection here, reconsider so and so, whereby petitioner's selection so and so area was rejected. You are against the rejection.
Yes, rejection.
What remains?
Then, my lords, the my lords would also.
Selection so and so, so and so, so and so, strictly in accordance with the brochure.
Brochure, yes.
Then
The-
I'm saying that I'm giving you the entire relief. Nothing remains. Okay.
Now, madam, in view of the recent advisory, madam, the claim should be sponsored by DGR, madam. So,
I'm not concerned who will interfere there. That is for you.
yes, yes. But we will approach the DGR madam directly, madam, not to the.
You do whatever you
I think
feel
so,
like.
too.
You do as per the brochure.
As
As per your extent policy. I
Yes,
put it as extent policy
yes.
and guidelines. Like you heard Mr. B. Chaudhary,
My lords.
the learned counsel appearing on behalf of the petitioner. Mr. S. Bottakur appears on behalf of the respondent numbers
1 and 2, madam.
1 and 2.
Assessment, 3 and 4.
You are a central government council?
No.
Then you cannot appear. This is for central government.
6 and 7 I appreciate.
Huh?
6 and 7 I appreciate.
Mr. B. Gogoi appears on behalf of respondent number 6 and 7. None appears for the respondent number 3, 4, and 5. The petitioner herein has approached this court being agreed by the impugned letter dated 1/11/2024, whereby the petitioner's application for selection of service provider from Bharat Petroleum Corporation Company owned company operated COCO, bracket CO, COCO. Service provider at BP Srirampur, Kokrajhar was rejected, semicolon. For not to give effect to the letter dated 1/11/2024, semicolon, directing reconsideration of the petitioner's application in terms with the guidelines prescribed in the brochure dated 15/12/2023. Semicolon. Issuance of direction upon respondent number 6 and 7 to forward the petitioner's nomination for selection of service provider for Bharat Petroleum Corporation Company owned, company operated, bracket COCO, service provider at BP Srirampur, Kokrajhar, in accordance with the directives contained in the letter dated 5/4/2024 and advisory dated 18/9/2024 issued by the Directorate General Resettlement, Ministry of Defence, Government of India, and in the alternative, directing the respondent authorities to cancel the selection process for selection of service provider for Bharat Petroleum Corporation Company owned, company operated, bracket COCO service provider at BP Srirampur, Kokrajhar, pending appropriate amendments in the guidelines contained in the brochure dated
12, my lords, it should be 12.
2023 by the respondent number 1 in accordance with the directives contained in the letter dated 5/4/2024 and advisory dated 18/9/2024 issued by the Directorate General Resettlement, Ministry of Defence, Government of India. Full stop. Mr. S. Bhattacharya, appearing on behalf of the respondent numbers 1 and 2, submitted that the competent authority had accorded approval for cancellation of the selection process for service provider for BP Srirampur. Full stop. He further submitted that upon such cancellation, he further submitted that this very aspect of the matter is therefore brought to the attention of this court so that the respondent number 1 and 2 can take appropriate action in accordance with law. Full stop. In that regard, he has placed before this court an email dated 27/10/2025 issued by the Senior Manager Legal BPCL, which is kept on record and marked with the letter X. Full stop. Taking into account the above,
In the affidavit filed by respondent number 6, there are 8 we have accepted that there was some flaw on our part in
Yes.
admission is there from. There is
this court further takes note of that the respondent number 6 has also filed an affidavit in opposition wherein it has been mentioned where
Last sentence, right? It is rejected there.
wherein it was observed, it was mentioned that the Directorate General of Resettlements letter dated 5/4/2024 was neither addressed nor received by the respondent number 6. it was further mentioned that the KSB letter dated 12/4/2024 was received on similar lines of that of the respondent number 4's letter. In addition to that, it has also been mentioned that the respondent number 2 had approached and handed over the letter of the then Directorate of Sainik Welfare Assam for volunteer ex-servicemen for managing an existing petrol pump at Srirampur, Assam. The then director, acting in good faith and as a welfare measure for ex-servicemen, wrote to all Jila Sainik welfare officials for details of volunteer ex-servicemen for the job. On receipt of 4 volunteers, the same was forwarded to the respondent number 2 by the letter dated 26/6/2024. It was mentioned, it was regretted by the respondent number 6 that while doing so, the KSB letter dated 12/4/2024 was not taken into consideration due to oversight. Taking into account that the respondent number 1 and 2, who are the who are the settling authorities, have taken a decision for cancellation of the selection process which have been impugned in the instant proceeding. And there is a move to do this, and there is a move to go ahead with a fresh selection proceedings by following the extent policies and guidelines. This court is of the opinion that nothing further survives in the instant writ petition. Accordingly, the instant writ petition stands closed, thereby taking on record the decision of the respondent number 1 and 2 for cancellation of the selection process, which is impugned in the instant proceedings, as well as the stand of the respondent number 1 and 2 that fresh selection would be done in accordance with the extant policies and guidelines.
There is otherwise that prayer.
There
is otherwise that prayer for amendment of the brochure, my lord, because the entire issue, my lords, came up because they had not amended the brochure. There were guidelines.
Therefore, extent policies and guidelines.
Yes, yes. Deeply.
Matrix, Lordship. Lordship, here by this, my lord, by order dated 13/8/2025, given liberty to the petitioner to serve thusly notice, my lord. I have served. Page, I also filed affidavit, my lord, page 34 of the affidavit.
Whom have you served?
My lord, Chandan Sharma, Commissioner Secretary, my lord, their seal is there below, my lord. Special seal content.
Who received it? Who is Chandan Sharma?
But he was the Commissioner and Secretary, the Government of Assam, PWD Department. He was the contender.
Who has put this signature?
My lord, the petitioners went to the office, the official person, my lord.
Huh?
Some officials, my lord.
You cannot say some official.
of
See,
the-
this is a confirmed matter, na?
my lord, he went to their office, my lord. The person, my lord, he also put signature also in his.
Whose signature it is? Who has signed it? You have to mention this, na? Some M Das, who is he? Who took this? Did the petitioner go there?
Petitioner went there, my lord.
Huh?
Yes, my lord.
Where is it mentioned? He means who is served?
My lord, he went to their office and that person, some
Who? There are 5 petitioners. Who is the petitioner?
petitioner Hamidul Islam.
Where is he mentioned? That he has gone there?
That is paragraph 3, my lord, page
Read it.
31.
Read it.
That the deponent begs to state that this honorable court right order dated so and so past in so and so was pleased to allow the petitioners to effect service upon the sole respondent by way of the stay. Accordingly, he has served notice upon the sole respondent. Petitioner, my lord.
Who? Are you therefore not required to say who has served it, to whom it has been served? See, these are quasi-criminal proceedings.
But the petitioner number 1, the Hamidul Islam, the deponent, he went there.
Isn't this an affidavit of service wherein he has to mention who has served whom? The petitioner number went to the office of the respondent and in his office so and so received on behalf of so and so. Isn't it? And put
Yes,
the signature which appears out there is the signature of so and so, who is the personal assistant. You have to mention something, na?
It will be.
Where is it?
That, if required, my lord, I will file some.
Take a fresh steps.
My lord.
The affidavit of service so filed on 16/10/2025 does not seem to be, is not satisfactory. Inasmuch as there is no mention as to who had served the respondent and on behalf of the respondent who had received. Considering the above, the affidavit of service is rejected. Petitioner is directed to take fresh steps by way of dusty routed through the registry of the spot and file an affidavit of service on or before the next date. List the matter on 1st of December 2020.
Some earlier, my lord.
Okay, 24th of November.
I'm dead.
43. My lord, our affidavit is received today, my lord. We file it, in 2 days, we file the affidavit. We have received the signed affidavit. Taking.
Mr. I. Bhottako, the Learned Standing Council of the PHE Department submits that the affidavit is going to be filed
Day after.
within 2 days. So list this matter on 12th of November 2025. It will be given to the petitioner to file reply if any.
What if,
Affidavit file?
No, your lordship, I take some time, your lordship.
When?
10 days time, your lordship.
Ms. Ardeka, appearing on behalf of the respondent number 1 and 2, submits that a final opportunity be granted to respondents to bring on record the stand by filing the affidavit. This is the matter on 1st of December 2025. Affidavit be filed without fail and a liberty given to the respondent number 1 and 2 to file the affidavit on or before 26th of November 2025.
45.
My lord, in this case, petitioner received the remaining amount, lordship.
Huh?
Petitioner received the remaining amount, lordship, already received. As such, my lord, contempt may be closed, lordship.
It has been submitted that Mr.
B. Borgunhai, lordship.
B. Borgwan, you are there in the matter?
Lordship.
Mr. B. Burgoyne, the learned counsel appearing on behalf of the petitioner submits that the petitioner have already received the amount,
Remaining amount.
for which amount, and accordingly, the order dated 26/5/2025 passed in WPC number 224/2025 have been duly complied with. So considering the above, the instant contempt proceedings stands stop. You are appearing for?
The sole respondent, Your Lordship, A. Devani.
Huh?
A. Devani.
What? You are appearing for which respondent?
Appearing for Your Lordship.
Respondent number one.
Respondent number one, Your
So
Lordship.
and so appears for the respondent number.
Only one respondent.
Sole
Only
respondent, Your Lordship.
double effect.
Your Lordship.
May I please, Your Lordship? Lordship, this contempt was against the non-compliance of the order dated, Lordship.
Yes.
27/6/25, Lordship, and they have complied it, my lord. Complied, my lord.
See? Mr.
PK Bordoloi. PK Bordoloi.
Your name is there?
Yes, Lordship.
Mr. PK Bordoloi, the learned counsel appearing on behalf of the petitioner submits that the order passed by this court dated 27/6/2025 in WPC number 3641/2025 have already been complied with. Ms. So-and-so appears on behalf of the respondent. So respondent?
So number 1 and 2.
Both, Lordship.
Number 1 and 2. Taking into account the above, the contempt proceedings stands dropped. Now, taking into account the above, the instant contempt application stands closed. Here I have not issued notice, na?
Lordship, we gave copy.
By this. Oh, you. Young matter.
Application for recalling an order passed. by-
Where's your friend?
My lord, he was here indeed. In the afternoon, I saw him, but I don't know now, my lord, because maybe he must have left, I think, because in the afternoon, I just saw him passing today. Mr. Shamaria was there.
Have it on some. What has happened to the contract?
Contract, my lord, I have been, my lord, they have evaluated my technical bid. I have been, my lord, rendered successful in the technical bid evaluation, and the final bid, my lord, in the financial bid also, they have evaluated the bid. Only the work orders are yet to be issued to the, my lord, the selected candidate, my lord, the contractors who were chosen for financial bid, my lord. So, my lord, after a week, maybe the orders may also come out, my lord. And maybe, my lord, the petitioner may also get a order. I do not know, of course, my lord, provided what they are contemplating to do, my lord.
Oh, yeah, John.
My lord, can I join it? My lord, only thing is that if your lordship may kindly allow this interlocutory application for recalling the order, then on merit of the case, your lordship may hear the writ petition, my lord. Because, my lord.
Why?
No, my lord, I'm just submitting, my lord, if at all my lordship is keen to.
Give me a good reason.
No, my lord, I'm just leaving it to your lordships.
Why? Give me a good reason. I will like to help you out, but give me a good reason.
My lord,
But the reason what Mr. K. Chaudhary said is not good. You have participated. You have been given all the benefit. You are now being considered. Why are you petitioning? You want to challenge that some persons from the scheduled categories did not get it, could not participate?
My lord.
Is a question which may be a case of a PI. Filing a writ petition out here where you can participate. And you have participated.
Yes.
You see,
my lord,
a person can very well file a writ petition.
Yes, my lord.
May not be a person interested. If you go into the case of
SP Gupta.
the SP Gupta, the locus for filing a writ petition is there.
There.
But when You have participated in the said process and you have not been affected.
An injury, my lord, with all due respect, my lord, an injury may not be caused to me directly by the fact that I'm in a capacity today to have the resources to pay for the security, my lord. But the only point that I'm raising, my lord, is having a very fine line which distinguishes, my lord, the case from a PIL. Why? Because, my lord, I, as a member of the same community, is now aggrieved by a fact that action has been initiated to deprive similarly situated persons like me who may not be interested to come before this court because I am the only contractor who has participated. Now, there may be people who, because of this impugned insertion of this clause, which disentitles people like us not to, my lord, give or not to have the benefit of 50% relaxation in depositing this particular security deposit. So maybe there must have been some people who have been already deprived. So we have a very limited prayer, my lord. This thing can continue, but only thing is that this may set a precedent that tomorrow again they may come with a similar kind of an action in which, my lord, some other people may be deprived, like who belongs to our community. Because what I have, my lord, understood from the plain reading of judgment, my lord, in fact, I, being a member of that community, have some locus to at least ventilate, although, my lord, I have participated in the process, my lord. Because this is a very fine line, actually, what I could understand, my lord. Not a very, my lord, not a very kind of a immediate right or a fundamental right which I have to espouse it before your lordship, my lord. Because had it been a case that I didn't have the capacity to have the resources, then my lord is absolutely correct. Then definitely the case would have been entertained by my lords. But now there is a possibility, my lord, I'm saying, that maybe tomorrow or maybe, my lord, some other people belonging to my category have been deprived of in participating because of the fact that there is this impugned clause already been inserted.
Hello, let's see SP Gupta.
I'm sorry, my lord, I have the online copy. May I mail it, my lord?
Oh, you're not prepared?
I didn't get a book, my lord. I did that printout is quite voluminous, my lord. So I had it on my online copy, my lord.
Read
Read, my lord.
paragraph you were in.
My lord, it starts from actually paragraph number 23, my lord. May I read, my lord? My lord, my paragraph from 17, in fact, my lord, 17 is quite relevant. My lord, may I read, my lord? It may therefore now be taken as well established that where a legal wrong or a legal injury is caused to a person or to a determinate class of persons by reasons of violation of any constitutional or legal right, or any burden is imposed in contravention of any constitutional or legal provision or without authority of law, or any such legal wrong or legal injury or illegal burden is threatened, and such person or determinate class of person is by reasons of poverty, helplessness, or disability, or socially or economically disadvantaged position, unable to approach the court for relief, any member of the public can maintain an application for appropriate direction, order, or writ in the High Court under 226, and in case of breach of any fundamental right of such person or determinate class of person in this court under Article 32, seeking judicial redress for legal wrong or injury caused to such person or determinate class of persons. My lord, where
Tell me the concept of public interest litigation was there prior to that?
No. This is the beginning, in fact, my lord.
So therefore,
My lord.
don't you think that this is an involvement? Does it say that you don't need to file a public interest litigation, but you have to can file a writ petition? See, public interest litigation is also 226.
Yes, my lord, of course. It's correct.
But the only thing is, anybody else who is not being affected can approach the seeking certain that their benefit, their interests of all these people. I am okay. But as a member of the public,
my lord.
I'm approaching the court so that these particular clauses be made a mandate of law in all cases. When you are having a notice in writing,
My lord, in context,
so that they can also participate.
correct.
But in a written petition,
My lord,
that is why it is being given to a division bench.
my lord,
Public interest litigations have been taken up by the division bench.
yes, my lord.
Because there, apart from the necessity of passing necessary order,
Yes, my lord.
the court will also see the bona fides of that person concerned.
Absolutely. What interest I have.
Okay.
Yes, my
So
lord.
that is for the public interest litigation.
Correct.
In a written petition, simplicity, which is,
Simplicity, my lord.
why should this court look into, taking into account that there are many judgments of the Supreme Court that if you are not agreed, why should you?
Come.
Unless you file a public interest litigation. That is why I'm saying,
Yes, my lord.
this is the concept, there's no good.
Of course, my lord. No.
Because
There's no
Supreme Court
denial to
doesn't
that.
say so. Yes,
yes.
a person very well can come.
Yes, my lord.
Therefore, you have the public interest litigations. It is
Even-
not that you are not stopped.
No, no,
Go
no.
ahead.
Correct.
Go before the division bench and say that, look here, I can very well participate in this, but you need to have these clauses.
Be changed. Of course, my lord.
That is why I'm saying, I asked you, why not a PIL? It is not that, because the PIL is also 226.
Absolutely, my lord. Both comes under the same my lord, article.
There, one thing will be seen, apart from the others, a bona fides.
Bona fideness, correct, my lord.
Or a person who is otherwise, because you see, we have also to look into it. 79 is okay, a fantastic thing. This happened in 79, no?
Yes, my lord, 79. 81 it came out.
81. At that point of time, the law of 226 was evolved.
Evolving, correct, my lord.
As of now, we are in 40 years,
After-
45 years down the line.
Yes, my lord.
The luxury in a writ proceedings on the 226 for spending time in a matter of this type.
Correct.
When there are many other litigations.
Coming.
And whereas this matter being similar matter, same matter can be very well agitated before the division bench, where there is a public interest litigation can be taken. Is another aspect. Courts doesn't have the luxury.
Correct.
They I had. Luckily, I am having time. But normally the
Of
court
course,
do not have the luxury
Of
of
course,
time. Deal with it as to whether this clause should be reserved, whether this benefit which you are asking is a benefit under what provision? Under which article? Whether in article chapter?
My lord, this comes under article actually 46 because why I'm.
It's a directive principle.
Yes,
of it.
because
That is another thing.
Yes, after-
Otherwise, in chapter, there is a chapter, the constitution, I think chapter 46. See,
46,
the problem is,
So long as my lord, my
this is part 16.
part
Part says, now you are asking enforcement of section. You see, as per article 15,
15 and 16 are, my lord, they are traditional provisions for education institution and for public employment. They do not say about government contracts or, my lord, government contractual matters, my lord. So what I'm trying to, my lord,
no, employment is 16.
16, my lord, and for education institution is 15.
Why do you say education institution is 15?
My lord, for the reservation in various education institution, my lord.
Let's see, where?
My lord,
Read article 15.
yes, my lord. Not in 15 in, my lord, let's read it, my lord. No, I'm sorry, my lord.
It is general.
In general, correct.
15 is general.
General, it's only
No.
16.
15 being general,
Mm,
there's an enabling power
Yes, my lord.
under 15.4,
15 for correct.
which is not an exception, but it is in further
In
continuation of the powers which have been given under 15.1
51,
and
correct.
Article 14,
14, my lord. Absolutely.
thereby to have level playing
Level
ground.
playing field, my lord.
So it will be your class is not directly under 46.
If not back then, correct.
May also come under 15.
15, absolutely.
But if that being an enabling power of the state,
My lord.
unless that the state have the policy, can
Even
we
courts
impose
cannot.
it?
Even courts cannot, of course. my lord.
That's the problem. Think a lot.
Yes, my lord.
We'll see when the matter.
I'm obliged, my lord.
Obviously, something more relaxing
My lord.
when you take up this matter.
Highly obliged, my lord.
It's the matter when
Any day
taking
convenient, my
into
lord.
account that Mr. S. Samaria, the Learned Council for the Seats Corporation of India, is not of Assam.
No.
Assam, no?
Yeah, some speed
Is
corporation.
not present, matter stands adjourned to be listed again on 17th
My lord.
November.
My lord. I'm highly obliged, my lord.
48.
Either development of public interest litigation, I may be wrong, but I think it developed from there.
It has developed from 1981. From there, it has started.
From
For the first
there,
time,
the concept have developed.
Developed.
Yes, so therefore the power, therefore thereupon, after these, there has been a rampant filing of
all
writ petitions by everybody.
and in fact, PIL also. There have been rampant filing as your
No,
lordship
no,
has
rampant filing in the form of a PIL or
Yes,
they were
yes.
nomenclated a PIL,
PIL, exactly.
which led the Supreme Court to pass an order thereby saying that these matters will only be taken as a PIL
Correct, madam.
and thereby having a streamlining a particular procedure.
Correct.
And this resulted in our High Court also framing certain guidelines
madam,
as
correct.
per the Supreme Court
Correct,
judgment.
absolutely, madam.
And therefore you meet these parameters.
Correct, madam. They have madam, bottleneck the entire process, madam, now.
That is why.
That is why, madam.
Chal.
Anyway, madam, I'm obliged.
Yes, what is this?
Lordships, there are
Item
two
number
IA.
48.
Lordships, there are two IA, 3 to 7, it is for correction of the name. The correct name should be Pranali Talukdar, your lordship. It was during the filing of the IA for substituting the original petitioner number 1. The name was wrongly written as Pranali Talukdar Nath, your lordship.
Then
Lordship, so for that, the correction of the name of the petitioner
this is
number
IA.
3278, your lord.
This is for
1C, your lord, petitioner number.
oh. Who is it paying? State revenue and Hello. This is an application filed for correction of the name of the petitioner number 1C,
Look.
which should have been Mrs. Pranali Talukdar
Lord.
and not Mrs. Pranali Talukdar Nath. The respondent appearing on behalf of the council appearing on behalf of the learned council appearing for has no objection. Taking into account the above, the name of the respondent petitioner number 1 be read as Sri Mrs. Pranali Talukdar and not Mrs. Pranali
Talukdar Nath.
Talukdar Nath. The council appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court, and the registry shall make necessary correction of the same by in the CIS as well as also update in the same. Also update in CIS and now, what is this? The other one who died?
Lordship, petition number 1C in that case.
What is this matter about?
Lordship, this is in respect of compensation, land acquisition. Land acquisition compensation, your
We
lord.
are filing this petition after 50 years. And in a similar situation, ordinance benches pass order that rejecting his claim. And thereafter, they are going before the division bench also did not enter at a single judge order. That's the issue.
Hello. Who died?
Lordship, petitioner number 1D, your lord.
This is an application filed for substitution of the petition number 1B, who expired on 13/11/20
16/4,
on
16/4/2021, Lordship.
15/4/2021. 16/4/2021, leaving behind the applicant herein. Full stop. The respondents have no objection to the same, and accordingly, the respondent number,
1D.
the
Lordship.
petition number 1D is substituted by the applicant. Full stop. The counsel appearing on behalf of the party is directed to file fresh memo of party within the 7 days. Make this very, I can.
Lordship.
Now let's take the petition and dismiss.
Lordship.
Are you?
I'm not,
We have time till 15 minutes.
I'm not prepared with the writ petition, Your Lordship.
What? 2014 writ petition, it should have been finished.
Lordship,
off.
we had filed our wakalatnama on 2nd of September only in this case, Your Lordship.
Yeah. Now, where will these people find? No, they won't find any details. Can't happen. You have not, you have filed affidavit.
Lordship.
What did he say?
Revenue Department has filed a petition.
How are you connected with Sukhoda Bollabosya? Sir, you are all talukdar. You know business.
Lordship, me fix a date. I am not active with the.
Then why didn't you approach? You filed some representation in the year 19, when? Passed an order on 10/5 rejecting the claim of compensation in connection with the acquisition of NX 31 during 19 years. That the order as per manual of the so and so. And how can you approach this court? Okay. When should we dismiss it? Give me a time. When? Tomorrow?
Lordship, day after tomorrow.
Okay, day after tomorrow we dismiss this type of matter.
2014.
Along with
Already.
cost on the council for entertaining this type of.
Lordship, recent.
You argue, and if your senior comes, the cost will be double. If you appear, no cost. That is the incentive.
Lordship.
Dismiss to dismiss it. But if your senior comes, the cost is, there's a cost. Leave it to your.
Lordship.
So taking the main repetition, list the matter on 35 on 1st of November 2025 for this book as the first time. You're having court on 1st November. Huh? Dismiss it on 1st.
49.
No amended cost list filed.
Wait, please, Lordship.
Why, have you filed or not?
Yes, Lordship. I filed in the morning.
Because so and so submits that the amended cost title had been already filed. Extra copy is not submitted?
Respondents 2, 3, 4, 5, 7, and 8. Put it up,
Lordship, I will submit it by tomorrow.
The Miss So and so appearing on behalf of the respondent number 2, 3, 4, 5, 7, and 8 submits that the extra copies have not been served. Taking into account the above, the petitioner is directed to serve extra copies by tomorrow. List the matter on 1st of December 2025. In the meantime, the respondents shall bring on record their stand by filing their.
Offline.
May I please?
Service complete, not complete?
Lordship will file our dusty affidavit, Lordship, in the next week.
Huh?
In the next week, we will file our dusty affidavit, Lordship.
Oh, then we have to fix another date. Service being not complete, this is the matter. Again on 17th of November 2025, giving an update.
Much.
55.
May I bring? I have taken dusty service, but refused to accept. And also by speed post.
Huh?
I'm for the
Then service upon respond number 4. Complete. Refuse to accept.
Yes. And speed post also I have taken steps.
This court have taken note of the affidavit of service. And from a perusal thereof, it is seen that the respondent number 4 had refused to accept the notice. Considering the above, this court accepts the service upon the respondent number 4 to be complete. List this matter on seventeenth of November 2025, on which date for admission and on which date the respondent, the registry shall also give an update as regards the service status of the respondent number 4, taken by way of speed post. You also bring on record. The respondent official shall also bring on record the stand by filing their.
Like
56.
May it please the Lordship. Lordship, as per the office note dated 24/10/2025, service is awarded on private respondent, Lordship.
Private respondent.
Respondent number 6.
What to do? You've taken steps by the state.
Yes.
Have you filed the affidavit of service? No.
No.
Eh? What has, oh, affidavit of service not given. Anyway, the service upon the respondent number 6 is not complete. List this matter again on 24th of November 2025. Interim order shall be considered on the next date. The respondent to the registry shall place before this court an update status as regards service upon the respondent. It's
57.
Well, in this case, earlier it was directed to take register steps. But the section has
now it will be automatically
post.
taken as, yeah.
Yes, my lord. So, my lord, additional court fee, stamp duty, I will pay, my lord.
Who is appearing for whom? Why you are taking steps?
Yes, my lord, steps taken.
Steps taken against whom?
Respondent 5, my lord.
Who is respondent number 5?
Respondent 5 is a person, my lord, from whom I purchased the vehicle, my lord. My name has not been transferred, my lord. The vehicle
How
was
did
not
you
transferred in
purchase?
my name, my lord.
How did you purchase?
My lord, registered, not registered, my lord,
It should be
agreement was
dismissed.
there.
Isn't it, madam? Shouldn't it be dismissed? How can there be a transfer?
My lord, some amount has been paid, my lord. Some amount is remaining.
No, unless you have, then what is this? Anyways, service upon the respondent number 5 being not complete, leaves the matter after completion of service.
My lord, let it be speed post, my lord. Let it be speed post, my lord. Otherwise, unless there is a order, they are declined.
Okay. Mr. M.K. Kolita appearing on behalf of the petitioner submits that he may be permitted to take fresh steps upon the respondent number 5 by way of speed post. Taking into account the above, list this matter again on 3rd of December 2025. The steps be taken by steps by way of speed post be taken upon in respect to the respondent number 5 within 3 weeks.